Ruangan ini memiliki 1 lift di sebelah kiri dan 3 tangga darurat. 2 tangga darurat berada di depan pintu masuk ballroom dan 1 tangga darurat yang berada di belakang. Ruangan ini memiliki toilet pria dan wanita yang berada di luar ruangan di sebelah kanan. Rayz Hotel Universitas Muhammadiyah Malang memiliki 2 titik kumpul yang berada di tempat parkir. Ruangan ini dilengkapi alarm pemadam kebakaran yang berada di atas plafon ruangan ballroom, 1 hidran dan 1 alat pemadam api ringan di luar ruangan di sebelah kanan. Apabila terjadi kondisi darurat seperti gempa bumi, kebakaran, dan sebagainya, jangan panik, tetap tenang, selalu waspada, dan menuju titik kumpul. Apabila terjadi gempa bumi, jauhi dinding karena akan berisiko runtuh. Lindungi kepala Anda menggunakan 2 tangan, berjalan cepat namun jangan berlari, silakan menggunakan tangga darurat dan menuju titik kumpul. Apabila terjadi kebakaran, alarm pemadam kebakaran akan menyala. Diharapkan untuk tetap tenang dan jangan panik. Agar tidak terjadi gangguan pernafasan, tetap menggunakan masker dan bernafas seperti biasa. Silakan berjalan merunduk keluar dan menuju titik kumpul. Pada kondisi darurat, bagi wanita yang menggunakan sepatu hak tinggi, kami sarankan untuk dijinjing agar tidak cedera. Ikuti arahan petugas untuk mengurangi segala risiko. Selama berada di lingkungan Rayz Hotel Universitas Muhammadiyah Malang, diwajibkan untuk tetap menggunakan masker dan tetap melaksanakan protokol kesehatan. Demikian safety briefing yang kami sampaikan, harap untuk dipatuhi. Selamat beraktivitas, semoga Allah melindungi kita semua. Wassalamualaikum warahmatullahi wabarakatuh.
Excellency, distinguished guys, participants, ladies, and also gentlemen. Welcome to this Rayz Hotel. Assalamualaikum warahmatullahi wabarakatuh. So again, good afternoon, Bapak Ibu. Thank you so much for coming today in this Rayz Hotel UMM Malang for the opening ceremony of 3rd International Conference on Law Reform, held by Law Faculty of University of Muhammadiyah Malang under the topic Understanding Law Reform on Post-COVID-19 Pandemic. So today, Bapak Ibu, I am Arum Puspitasari, going to be the host. And now in front of us, I'd like to greet the Vice Rector of Universitas Muhammadiyah Malang, Professor Dr. Samsul Arifin. Hello, Prof. And also the deans who already joined us today here, the deans of University of Muhammadiyah Malang, as well as the directors. We also have Bapak Solahuddin Al-Fatih as the General Chair of the committee. We also have 7 co-host deans and also maybe some of the representatives who will receive the co-host certificates today. And I also want to greet all of you participants who now watching us online through Zoom meeting. So we have Bapak Ibu now, you here in online meeting as well as in offline meeting with us today in Rayz Hotel. And Bapak Ibu, ladies and gentlemen, please allow me to read the agenda for today's
Recording
event.
in progress.
Okay, so the first meeting for today, the first agenda is reciting the Holy Quran, and then followed by the second agenda, which is singing Indonesia Raya, the Indonesian national anthem. And then followed by the third agenda, which is singing Sang Surya. After that, we will have welcoming speech by the General Chair of the Committee, Bapak Salahuddin Al-Fatih, SHMH, and then the opening remarks will be delivered by our Vice Directors of Academic Affairs, Professor Dr. Samsul Arifin, MSI. And then, Bapak Ibu, as I mentioned previously, there will be granting of co-host certificate and signing the MOU, which will be guided by our Dean, Bapak Dr. Tongat, SHM Hum, and then followed by the next agenda, which is the keynote speaker, Bapak Ambek Paramarta is going to give the keynote speech. And after that, the agenda will be followed by parallel sessions. So, without further ado, let's go to the first agenda today, which is the recitation of Holy Quran. Please, yes.
Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasy syaithanir rajim. Bismillahirrahmanirrahim. Dzalikumullahu rabbukum la ilaha illa hu khaliqu kulli syai'in fa'buduhu wa huwa ala kulli syai'in wakil. La tudrikuhul absar wa huwa yudrikul absar. Wa huwal latiful khabir. Qad ja'akum basairu min rabbikum faman absara falinafsihi نفسه ومن عمي فعليها وما أنا عليكم بحفيظ وما أنا عليكم بحفيظ صدق الله العظيم. Assalamualaikum warahmatullahi wabarakatuh.
Okay, then Bapak Ibu, now we are on the second agenda. Now I want you, Bapak Ibu, please stand up because we are about to sing our national anthem, Indonesia Raya, followed by Sang Surya. Indonesia Raya. Sang Surya. Ladies and gentlemen, please be seated. Now go to the next agenda is welcoming speech by our General Chairman, Bapak Salahuddin Al-Fatih, SHMH. Please come to the stage.
Assalamualaikum warahmatullahi wabarakatuh. In the name of Allah subhanahu wa ta'ala, the most gracious and the most merciful, the Honorable Vice Rector of Academic Affairs, Al-Islam and Muhammadiyahan, Prof. Samsul, Sakalangkung Prof. Depada, the Honorable Secretary of LPPI, University of Muhammadiyah Malang, Opa Tommy PhD, because her face look like Korean actor, so he will known as Opa. The Honorable Dean Faculty of Law, University of Muhammadiyah Malang, Associate Professor Dr. Tongat, as well as Prof. Sam call Pak Karni Ilyas. All my beloved speakers in the Zoom who has joined Dr. Nur Anita Abdullah from University Utara Malaysia, all beloved audience, asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluh. Rabbi israh li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. First of all, let's thank to Allah subhanahu wa ta'ala who has given us some mercies and blessing so we can meet in this third international conference on law reform under the topic Understanding Law Reform on Post-COVID-19 Pandemic without any trouble and obstacle. Secondly, may salawat and salam always be given to our Prophet Muhammad sallallahu alaihi wasallam, who has bring us from the darkness to the lightness as named as Islam. Thirdly, I would like special thanks to my beloved speakers, my teachers, my mates, Professor Oliver Fu from Northwest University, South Africa, Dr. Fernando Arletas from Universidad de Zaragoza, Spain, Associate Professor Dr. Nur Anita Abdullah from University Utara Malaysia, Cekli Setia Prativi PhD candidate from Mahidol University Thailand, and also Associate Professor Dr. Herwastuti from University of Muhammadiyah Malang. Fourth, special thanks also to our co-host Universitas Negeri Gorontalo, please welcome to Malang, Universitas Surabaya, Universitas Trisakti, Universitas Islam Riau, Universitas Muhammadiyah Surabaya, Masatria and friends, Universitas Muhammadiyah Sukabumi, and also Universitas Muhammadiyah Ponorogo. In this conference, we received almost 100 papers from all around the world, such as from the Philippines, Japan, Kingdom of Saudi Arabia, Netherlands, Hungary, Algiers, and also from Indonesia. Alhamdulillah. My apologize for our fault and mistakes during the conference. If you have any suggestion and recommendation, please text me or directly send us email inclar@umm.ac.id for further best INCLAR, the fourth INCLAR next years. Last, please enjoy this conference. Ke pantai membawa tikar. Cakep gitu biasanya ya. Ke pantai membawa tikar. Tikar digelar di atas tanah datar. Please enjoy the third INCLAR. Semoga acaranya lancar. Wallahul muwafiq ila aqwamit thariq fastabiqul khairat. Assalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Pak Salahuddin. That's actually such a great pantun. And again, I don't think I can make any now, yeah? So let's start today the opening. The opening remarks will be delivered by one and only Vice Rector of Academic Affairs, Professor Dr. Samsul Arifin, MSI.
Thank you for providing me. What's your name? Abah Arum. Thank you once again. Assalamualaikum. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. Innal hamdalillah la hawla wa la quwwata illa billah. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluhu la nabiyya ba'da. Rabbi israh li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Amin. Amma ba'du. The Honorable, the Dean of Faculty of Law, actually he has the real name, Pak Tongat, but sometimes, especially in the casual forum or in the informal forum, I always call him Tuan Karni. Yeah. Tuan Karni Ilyas maybe. Yeah. I think all of participants here very familiar with the name Karni Ilyas. I think the legend, the host legend. I forgot what the name in the program in TV. Yeah, ILC. Yeah, Indonesian Lawyer Club. And the Honorable, the General Chair of Committee, Muhammad Al-Fatih, that already delivered, I think, is a casual speech here, because even though you are from the Faculty of Law, I think you deliver to make a pantun. Yeah? So please translate to English, I think. Yeah. And amazing, because you also can speak Madurais. Yeah. The English temor apa? The East English. Yeah. Okay. And the Honorable, the Secretary of the in Bahasa LPPI, ya, Lembaga Pengembangan Publikasi Ilmiah. Ya. Lembaga Publikasi Ilmiah. And the Honorable, the keynote speaker, Bapak Y. Ambek, ya, Pramarta. He is Kepala Badan Pengembangan SDM, Kementerian Hukum dan HAM. If I try to translate to English, maybe the head of Human Resources Development Agency in the Ministry of Law and Human Rights. Is correct, Arum? Yes. Yeah, good. Yeah, and the honorable all of participants, let me say, Alhamdulillahi Rabbil Alamin, as expressing my gratitude to Allah Subhanahu wa Taala, our Lord, because Allah, our Lord, always bestow the blessing, bestow the health to us, so that we can gather, at least in the opening ceremony, for the conference, INCLAR, International Conference on Law Reform. Yeah. This conference is the third, it's the third conference. So it is the third years. So, ladies and gentlemen, on behalf of the Rector or the Chancellor, I would like to express my happiness and my highest appreciation to the Faculty of Law, especially to the Dean, and also to the committee, because we can maintain, we can maintain, I think is the one of the academic tradition. the conference is the one of the great academic tradition. For me, according to me, to organize the conference like this is something challenging. So maybe we can also say it's not easy actually, because not only how to implement after this finish, yeah. Because we have to think about what we call it in bahasa luaran dan capaian, output and outcome. Yeah, we have to think about the output and outcome, yeah, luaran dan capaian. That is, the paper that presented in the forum must be published in the journal that indexed by Scopus, for example, maybe also by WAS, yeah. WAS is correct, Pak Mas Fatih, yeah? Correct WAS, but I don't know about the extent the WAS. Web? Yeah, Web of Science, yeah. So I think Mas Fatih, of course, think about that, yeah. So don't worry. I think all of people that presented in this forum will publish in journal that has the good reputation. So once again, my highest appreciation to the dean and all of lecturer and also the staff in Faculty of Law, because you all can maintain the one of the academic tradition, and hopefully, yeah, this conference can continue in the next years, so we can gather again in the 4th international conference, in the 5th international conference, extra. So once again, thank you to all of lecturer and the Dean of the Faculty of Law. So in the last, I want to apologize because suddenly our rector, Pak Dr. Fauzan, he has another agenda. So Pak Rector asked me to represent him to deliver the opening remarks. The end, enjoy the conference, and let's say together to start, let's say basmalah together to start this conference. Bismillahirrahmanirrahim. And then what must I do?
Prof, we still need you to hit the gong together with Pak Tongat.
Yes. With this, the equipment?
Sure, yes.
Really?
I think so. Do we still have, this one, Prof.
Okay, I move to the front of you.
Yes. Yes. Should we take a picture, I think? Yes. Yes, sure. One more time. Okay, now we have 3 times gong. Yes. Waalaikumsalam warahmatullahi wabarakatuh. Oh, Pak Tongat, we still need you here because we are about to have certifications. Oh, Prof, you may have a seat. So after this, Bapak Ibu is the next agenda. We have several deans from several universities who are also contributed for today's event. So we call them as a co-host. So today, after this, Bapak Tongat and also the other 7 co-hosts today, or maybe the representative, will have certificate and also signing for the MOU agenda. So I invite some deans today who are already here. Dean of the Faculty of Law, University of Surabaya, Dean of the Faculty of Law, State University of Gorontalo, and then the third one is Dean of the Faculty of Law, University of Muhammadiyah, Sukabumi. And Pak Solahuddin, we also welcome you to the stage. Thank you so much, Bapak Dr. Tongat, and also our chair, General Chair, Bapak Solahuddin. Ladies and gentlemen, now we come to the main sessions of this event. Oh, the MOU is not yet coming. Let's have the MOU, and this one is for the Dean of State University of Gorontalo. I guess we still need the Dean of our faculty for the MOU signing. Yes, please, maybe the representative or also maybe the Dean of Faculty of Law from State University of Gorontalo. Can you please come forward for the MOU signing? Ladies and gentlemen, now we have come to our main session agenda today, which is a keynote speech by our keynote speaker, Bapak Y. Ambak Paramarta, SHMSI, who is Ministry of Law and Human Rights Expert Staff for Political and Security Affairs. Please, Bapak, come to the stage.
Assalamualaikum warahmatullahi wabarakatuh. Good evening, everyone. Honorable Vice Rector University Muhammadiyah and colleague, Dean of Law Faculty and colleagues, speakers, distinguished guests, ladies and gentlemen. Allow me to extend warm regard for Vice Minister of Law and Human Rights, Professor Edward Omar Sharif. And on behalf of him, let me to present his keynote speech. Keynote speech of Vice Minister of Human Rights. Legal reform is deemed to be indispensable in a democratic society. As a process, legal reform is an attempt by a country rearrange, evaluate, and improve upon various fundamental elements in the legal system. As history reveals, legal reform is often preceded by a momentum that demands for change. It is undeniable that the COVID-19 global pandemic crisis is one of the moments that become our point of reflection, especially in the legal field. In third international conference on legal reform held by University Muhammadiyah Malang, we need to work together through exploring potential space in law, so that law is not only seen for the law itself, but can guide the community itself in facing change. Traditionally, change in law are dominated by discourse within the law itself. However, during the pandemic, change to the law are dominated by two interrelated variables, namely the risk of public security and economic recovery. This speech will discuss the relationships between law enforcement through the dominant mode of punishment during the pandemic and the direction of regulatory formation that reflect Indonesia's political economy in the future. Challenge in law enforcement and formation during the COVID-19 pandemic can be traced from the practice of both in the last 2 years. As seen in other countries, various policy and methods have been implemented and tested for their effectiveness with one sole aim, namely to reducing the level of risk that exists in the community. In the context of law enforcement, a crucial thing that happened at the beginning of the pandemic was the decision to early release from prison. Spending in this case need to be understood as optimizing the coaching process outside prison. This was taken by the government considering various studies and WHO recommendation that prison and community factors are the most vulnerable to infection and humanitarian catastrophe. The existing data based on correctional database show that decrease in the occupancy rate, and at the same time there is increasing trend of home visit conducted by probation and parole office. From the law enforcement perspective, this phenomenon can be considered as an attempt to avoid individuals from being imprisoned, or we could use them decarceration. Undeniable, this measure appears to be impossible to implement before the pandemic. This measure appears to be, given the massive flow of incarceration in our criminal law system. However, due to public health consideration, the government inevitably took this step. In the context of law enforcement, in dealing with health risks in prison, the government issues and impose non-physical sanction on members of the public who violate the health protocol. The large imposition of pecuniary sanction developed a different character of law enforcement from pre-pandemic period, namely treating individuals in society as rational actors who will comply with regulation to pay a certain amount of money. In addition to fines, alternative sanction in the form of social work have also been practiced on many occasions throughout the country, especially in high-risk areas. However, the imposition of sanction and social work doesn't mean that the system is absent from the traditional criminal law enforcement, namely sanction against bodies. Criminal cases related to the COVID-19 pandemics, from hoax, corruption, to essential crowds, show us that punishment is only intended from individual and even that are considered to have highest risk, they should live physically unrestricted. Conceptually, the measure is actuarial. That is a punishment model based on community risk and management. The actuarial approach applied during the pandemic is principally influenced by risk calculation in terms of public safety. In the post-pandemic period, this approach can be an alternative policy in the law enforcement, although it must be based on a well-established basic concept. Regarding the formation of law, the latest regulatory quality index of regulatory issued by World Bank may say something useful. To 2000 and 1000, Indonesia source 0.07, which signify significant positive from 2019, when the score is minus 0.09. This significant progress is caused by many factors that have been pursued by all government officials at various levels. From this data, we may understand that the relationship between law, institution, and economy need to be positioned as a macro landscape that direct the formation of Indonesian law. By streamlining the existing regulation, we can expect that government commitment to ease of doing business will be more evident. There are two crucial policies in the current post-pandemic period. The first is improvement and preparation of derivative regulation of the job creation, which serve to streamline various legal norms into single statutory regulation. Second, the policy of ease of doing business supported by responsive bureaucratic and harmonization of regulation at all levels. In the context of this policy direction, we can at least identify that the law must become a common framework for institutions, both government and private, in an effort to restore the nation's economy. In the context of relationship between three variables between law, institution, economy, several points that become legal trajectories in the post-pandemic period, including first, the increasing capacity of government institution and collaboration between strategic actors. With the existence of job creation law, we need to look at the various adjustments that must be made by institution and how the collaboration model is established. All instruments in Indonesian national legal system cannot be separated from the aspect of capacity and competence of national legal human resources. Amid the government's focus on developing human resource, the capacity and competence of national legal human resources also need to be common concern. We need to realize that fragmentation that occur institutionally in the legal system has various implications at the individual level. This is reflected in common misunderstanding between law enforcement officials in the progress of interpreting the law at practical level. The future direction of human resource development aims to create a dynamic, hardworking generation mastering science and technology. In line with this aim, human resources is the national legal system can be viewed as law enforcement officer and law-related apparatus. Law enforcement official can be interpreted as a professional group that directly involved in the law enforcement process, while the law-related apparatus can be viewed as a professional related to law and legal academic, as a part of effort to develop the capacity and competence of national legal human resources. Interagency steps are needed to consolidate all legal human resources. The second is about the emancipatory driven legal change, directed particularly for vulnerable and marginalized community groups. This is principle reflected on the job creation law, which, for example, provides space and strong recognition for the micro and small enterprise sector. And we need to see the output and impact of this in the future. The third is how formation of law in the future can play a role as a form of governance of our society. The law and regulation issue are expected to be a framework for various actors at various levels to jointly achieve for economic growth. In this case, it should be emphasized that regulation is not only solution to problem in society. An excessive use of regulation can be counterproductive in achieving the state goals. Finally, the formation of law that reflect Indonesia's economic model will affect law enforcement, especially on how the state punishes members of society who deviate from the positive law. This trajectory could serve as initial food for thought to be discussed academically in this international conference. As an intellectual forum, the Third International Conference of Law Reform is expected to be able to produce works and support the development and progress of Indonesian law and legal system, both conceptually and practice. Thank you and good evening. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Bapak, Pak Ambak, for the very insightful knowledge. I believe all of you already also enjoy so much the speech from our keynote speakers. Bapak, Ibu, everyone seems like now, it is now on my watch, it's 2:20, so we still have plenty of time for a coffee break. So if you just visit or just came today, please enjoy. We still have lunch out there. We're also going to have coffee break for about maybe to 3:30, so it's quite a long time. If you think you want to like wash yourself, like getting fresher, make sure to do that. And if you haven't done the check-in also, please do that. But make sure we need to tell you back again that at 3:30, you need to come back here, because we are going to have our next sessions, which is preliminary one, my bad, and also preliminary session 2. Yes, please, Bapak Ibu. Now, if you need to do something else, Please do that. See you back again at 3:30. Thank you. Bapak Ibu, monggo yang mau menikmati kopinya, di belakang ada kopi yang suka hangat-hangat, yang suka dingin-dingin mungkin harus keluar dulu, ada es kopi di luar. Dan yang baru datang, Bapak Ibu yang belum makan siang, monggo silahkan masih ada di luar, yang ingin mungkin mandi dulu biar lebih fresh, monggo kami tunggu sampai jam 3.30 nggih.
Fakultas Hukum Universitas Muhammadiyah Malang merupakan salah satu fakultas tertua di Universitas Muhammadiyah Malang. Dalam perkembangannya, sebagai penyelenggara pendidikan hukum, Fakultas Hukum Universitas Muhammadiyah Malang tidak hanya memberikan teori kepada mahasiswa, akan tetapi juga menempa mahasiswa dengan berbagai praktikum mata kuliah, pendidikan latihan, dan kemahiran hukum, serta memberikan kesempatan magang bagi mahasiswa, baik wilayah regional Jawa Timur maupun di tingkat nasional. Hal ini sebagai upaya Fakultas Hukum UMM dalam membekali mahasiswa agar mampu bersaing secara nasional maupun global. Kebijakan pimpinan universitas yang secara progresif mengembangkan konsep UMM pasti dalam merespon perkembangan dunia pendidikan tinggi juga sangat selaras dengan visi Fakultas Hukum untuk mewujudkan sarjana hukum yang profesional, humanis, dan religius.
Assalamualaikum warahmatullahi wabarakatuh. Saya Dr. Tongat SHM, Dekan Fakultas Hukum Universitas Muhammadiyah Malang. Dalam rangka merespon dan menghadapi tantangan global yang kian sengit, Fakultas Hukum Universitas Muhammadiyah Malang mengukuhkan eksistensi.
Bapak Ibu yang ingin mengambil gambar dipersilahkan, karena besok kita sudah pindah gedung. Monggo kami siapkan backdropnya.
Pendidikan tinggi hukum.
Karena waktu cukup lama, silahkan jika ingin mengambil gambar.
Penerapan ilmu hukum.
Tim kami juga sudah siap membantu.
Sarjana hukum yang profesional.
Yang mau bikin TikTok, monggo.
Berbagai upaya pengembangan Fakultas Hukum Universitas Muhammadiyah Malang diorientasikan juga untuk mewujudkan konsep UMM pasti, yaitu pasti lulus dan pasti kerja.
Fakultas Hukum UMM memberikan kesempatan kepada alumni untuk mengembangkan keilmuannya dengan memberikan pelayanan kepada masyarakat di Posbakum Pengadilan Agama Kabupaten Malang. Fakultas Hukum juga mampu menghasilkan alumni yang tangguh dan dapat bersaing di dunia global.
Assalamualaikum warahmatullahi wabarakatuh. Saya Komisaris Polisi Sunardi Riono, jabatan sehari-hari Kepala Bagian Operasional Polres Malang. Saya bangga menjadi alumni UMM. Saya angkatan 1987. Apalagi dengan perkembangan UMM yang sekarang ini, sudah pasti saya merasa bangga saya sebagai alumni UMM atau Universitas Muhammadiyah Malang. Sesungguhnya saya ingin banyak berkontribusi kepada alma mater, karena banyak sekali sesungguhnya kejadian-kejadian atau permasalahan hukum yang saya temukan di masyarakat yang seharusnya bisa dikembangkan melalui riset, melalui seminar dan lain sebagainya di dunia perguruan tinggi. Insya Allah apabila ada mahasiswa yang membutuhkan untuk penelitian dan sebagainya, saya siap untuk membantu. Terima kasih Fakultas Hukum UMM. Wassalamualaikum warahmatullahi wabarakatuh.
Banyak prestasi akademik yang ditorehkan mahasiswa Fakultas Hukum, diantaranya juara debat konstitusi, baik di tingkat regional maupun nasional, serta berbagai prestasi lainnya. Selain di bidang akademik, Fakultas Hukum UMM juga mendorong dan mendukung prestasi mahasiswa di bidang non-akademik, yaitu di bidang sepak bola.
Nama saya Bagas Dewi Caksono, mahasiswa Universitas Muhammadiyah Malang, Fakultas Hukum dan angkatan 2017 semester 4. Saya memilih Fakultas Hukum Universitas Muhammadiyah Malang seperti yang diketahui karena Fakultas Hukum Universitas Muhammadiyah Malang dan di sana banyak talenta-talenta pesepak bola yang sangat handal, dan saya memilih itu karena saya pribadi dan teman-teman tertarik atas sepak bola sebagai hobi saya dan pekerjaan saya, dan ingin menjunjung tinggi nama Universitas Muhammadiyah Malang. Terima kasih Fakultas Hukum Universitas Muhammadiyah Malang. Salam sejahtera, salam olahraga. Wassalamualaikum warahmatullahi wabarakatuh.
Saat ini, Fakultas Hukum UMM menjadi salah satu fakultas yang menyelenggarakan pendidikan khusus profesi advokat yang bekerja sama dengan Peradi Kota Malang.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, saya Iwan Kuswardi, Ketua Dewan Pimpinan Cabang Peradi Malang Raya, yang selama ini sudah sering melakukan kerjasama dengan Fakultas Hukum Universitas Muhammadiyah Malang. Beberapa kerjasama yang kami lakukan membuahkan hasil yang sangat luar biasa. Bagi mahasiswa yang ingin praktek magang di Peradi Malang Raya, beberapa kali mereka juga sudah melakukan kegiatan-kegiatan bersama Peradi Malang Raya. Pada saat Peradi Malang Raya menginginkan satu inovasi, mereka memberikan satu inisiatif, yakni membentuk organisasi bantuan hukum atau yang biasa dikenal dengan LBH. Selamat buat Fakultas Hukum Universitas Muhammadiyah Malang. Wassalamualaikum warahmatullahi wabarakatuh.
University of Muhammadiyah Malang UMM is a private university sitting on a plateau of East Java in the city called Malang. The city is well known as a city of education, tourism and industry. Founded in 1964, UMM has now settled 3 campuses, namely Campus 1, Campus 2 and Campus 3. Devoted to environmental sustainability, UMM brings about a green and clean concept of campus. The concept is a vivid attempt to establish a vigorous, pure, and convenient atmosphere to boost creativity and productivity. UMM has also committed to open more green spaces by growing a variety of trees and flowers in every corner of the campus. UMM has achieved an outstanding acknowledgement from many associations, one of which is from National Board for Higher Education Accreditation for institutional accreditation with band A. In addition, UMM was awarded the Most Excellent Campus for the category of University in 2008-2016 by Cooperative 7 of East Java. UMM received international acceptance as it attained Asian Energy Award in 2009 and 2-star predicate from QS Stars World University Rankings in 2010-2011. UMM has also been an associate member of ONQA that is centered in Bangkok. The UMM laboratory has successfully achieved the accreditation of ISO 9001 and ISO 17025 in 2008 from the National Accreditation Committee. UMM students come from any part of the nation and other countries. The students are the inspired generations that aim to excel in their programs of undergraduate and postgraduate studies. UMM's 10 faculties over 56 study programs. Each faculty is equipped with a comprehensive laboratory that is located in the Central Laboratory of UMM. The Central Laboratory has been qualified to conduct laboratory testing for either external, company or other universities' users. The Faculty of Islamic Studies, the Faculty of Teacher Training and Education, the Faculty of Political and Social Sciences, Faculty of Law, the Faculty of Economics and Business, Faculty of Psychology, the Faculty of Agriculture and Animal Sciences, the Faculty of Engineering, the Faculty of Medical Science, the Faculty of Health Science, the Directorate of Postgraduate Program, The learning activities of UMM are monitored through a mechanism to guarantee the sustainability of a qualified higher education that is supported by representative facilities, such as library, mosque, student center, student dormitory, reading corner, information technology, meeting hall, theater, canteen, campus lake, and sport amenities. To add, UMM has also set up several business units, namely UMM Inn, UMM Dome, UMM Bookstore, UMM Hospital, UMM Gas Station, UMM Garage, Micro Hydro Power Plant, Sang Surya UMM Apartment, UMM Farm Center, and Sengkaling Tourism Spot. The facilities are the income center used to uphold the university operational expense in order to minimize the dependency from student admission fee. The business units might be possible to be an applied laboratory for students and can also help to create entrepreneurship. With a great enthusiasm to become a leading university with international credit, UMM has actively encouraged all campus elements to allow international partnerships. There have been notable MOUs made with international stakeholders in study program, faculty, and university level. UMM has as well regularly organized international conferences and seminars in collaboration with some abroad universities. Among others are consortium of 22 universities in Australia, an Australian consortium for in-country Indonesian studies, consortium of 33 universities in Asia and Europe in Erasmus Mundus and Erasmus Plus European Commission, Peace Corps, BGP Dutch Engineer, Al-Haramain Academy of Saudi Arabia, Korean Energy Economic Institute, Chemco Korea, Temasek International Foundation, Confucius Institute of China, Sakura Foundation, and any other representatives of neighbor countries. UMM is challenged to synergize the human resources that are high in diversity by students' coaching program. The programs are designed to upgrade the students' potential, skill, and characteristics. In early college period, students must participate in a program of shaping the characteristics of leadership. Devoted to nation, UMM has started to introduce a pattern of campus self-contained energy for the last 10 years by setting up a micro-hydro power plant. The pattern was then implemented more widely to construct micro-hydro power plant of Sumber Maro dan Karangsuko Village, Malang Regency, in cooperation between the Faculty of Engineering of UMM and Sumber Maron Foundation in 2009. Today, with sufficient support of electricity, there are more than 4,000 water pipe connections installed in the neighborhood. In 2016, UMM has transformed a slum village into a tourism village named Juli, a village of colors. The program was performed by the students of Communication Science Study Program in cooperation with Indana Print. This change has manifested a positive impact in a way that the villagers can now maintain their area cleanliness as well can improve their economic condition due to the increasing number of people's visits. At present, Jodipan is a new icon of Malang City. Since 2006, UMM has actively been involved in the revitalization of protected forests and national conservation of Bromo Tengger Semeru in partnership with PT Toyota Boshoku through JIFPRO, Japan International Forestry Promotion and Cooperation Center. The revitalized area, with the participation of students, lecturers, and local community, has now been 165 hectares wide. UMM always performs dedication for the nation, carries out energy with devotion for the sake of the progress and prosperity of Indonesia. UMM, from Muhammadiyah for the nation.
Foto yuk. Selfie. Guys, this is Malang, and we are students of UMM.
Seseru apa sih kuliah di UMM?
Apalagi ya?
Pokoknya seru banget!
Wait, dari mana sih perjalananmu dimulai?
Dulu saya masuk jalur prestasi akademik.
Jalur prestasi minat bakat.
Aku jalur reguler dong. Berproses di kampus putih sama dengan berkomitmen untuk jadi yang terbaik. Tagline tidak ada prestasi yang tidak dihargai selalu digaungkan di tiap kesempatan. Udah banyak living proof dari tagline itu. Tim robotik UMM yang jadi juara di kontes internasional bisa bebas kritik. Tulis novel yang diangkat ke layar lebar pun bisa dapat kesempatan yang sama. Yang punya bisnis sukses bisa banget ambil peluang ini. Dan masih banyak mahasiswa berprestasi lainnya.
Bukan mahasiswanya aja yang punya banyak prestasi, kampusnya juga loh.
Mulai dari akreditasi A dari BAN PT, peraihan ASEAN Energy Award, berkat komitmen UMM untuk jadi kampus hemat energi. Dan udah 13 kali berturut-turut loh, UMM jadi kampus swasta terunggul di Jawa Timur.
Eits, jangan lupa, laboratorium sentral UMM terjamin mutunya.
Laboratorium Sentral UMM terjamin mutunya karena tersertifikasi ISO 9001 dan ISO 17025 dari Komite Akreditasi Nasional. Selain terakreditasi di tingkat nasional, program studinya pun mendapatkan rekognisi internasional loh dari lembaga sertifikasi ALM-QA dan IAB.
Terbaru, di tahun 2021, UMM raih prestasi tingkat internasional sebagai Universitas Islam terbaik dunia versi Unirank.
But I guarantee you, there's a lot more to come. UMM, atmosfer internasionalnya sangat terasa. Mahasiswa UMM bisa belajar bareng mahasiswa asing yang ikut program reguler, KMB, dan mahasiswa sampai belajar budaya dan bahasa Indonesia di DIPA. Pojok budaya internasional di UMM juga banyak, mulai dari American Corner, China Corner, Thai Corner, India Corner, dan Aussie banget Corner. UMM terkenal mendunia lewat KKN dan magang internasionalnya. Belum lagi, kerjasama internasionalnya sangat luas. Let's say, a collaboration with Temasek Foundation Singapore for Community Engagement in both countries. Confucius Institute China yang beri kesempatan lecture and student exchange. ACCIS Australia yang buka pintu lebar bagi pelajar Australia dalam sosial budaya Indonesia di UMM. Lanjut lagi ke kemitraan dengan Medcare Jepang yang memudahkan lulusan langsung kerja di Jepang. Last but not least, partnership with Erasmus Plus, sebuah organisasi konsorsium Uni Eropa yang beri peluang mahasiswa, staf, hingga dosen belajar di Eropa. And there's still many more.
Wow, keren banget!
Proses perkuliahannya pun gak kalah keren. Ada program UMM pasti yang ngejamin mahasiswa buat pasti lulus 4 tahun, pasti mandiri, dan pasti bekerja.
Cuman itu aja ya?
Ya enggak dong, pendidikan karakter benar-benar diperhatiin. Ada P2KK yang menjadi langkah awal untuk kehidupan kampus. Pas kuliah, wawasan keislaman terus diasah. Lewat kegiatan semarak, literasi Quran yang terintegrasi dengan mata kuliah Al-Islam dan Kemuhammadiyaan.
Kegiatan ini tentunya membentuk jiwa mahasiswa yang peduli kepada sekitar, utamanya masyarakat. Let's go! Social skills mahasiswa benar-benar ditempa. Ada kuliah kerja nyata, pengabdian masyarakat oleh mahasiswa, program pengembangan desa mitra atau PPDM, dan banyak lagi lainnya. Makasih ya Pak. Dosennya pun gak kalah berprestasi lah. Community engagement dilakukan lewat berbagai cara, mulai dari pembinaan desa wisata, pertanian, hingga kemitraan. Kelas praktikumnya sangat menantang, karena dosen beri tugas mahasiswa untuk cari real client and together they solve its client problem. Misalnya aja, kerjasama dengan Indana Paint untuk CSR di Kampung Warna-Warni Jodipan. Wujudkan Berakseng jadi tempat wisata yang viral, dan banyak deh.
Nah, gak hanya itu aja loh, UMM punya banyak laboratorium terapan. Ini jadi wadah mahasiswa untuk belajar dan menerapkan apa yang sudah dipelajari di kelas. Laboratorium terapannya mulai dari Rumah Sakit Umum, Rayz Hotel UMM, Kapal Garden Hotel, Rooftop Resto and Cafe, Taman Rekreasi Sengkaling, Bengkel Mobil Rinjani, SPBU UMM Energi, UMM Dome, Bank Syariah Bumi Rinjani, Pembangkit Listrik Tenaga Mikrohidro, Kesemua laboratorium terapan ini bakal memperkuat pengetahuan dan pengalaman mahasiswa.
So, what are you waiting for? Let's be one of the wet campus students. Raih mimpi, prestasi, dan inspirasi.
Menjadi hebat itu tak hanya berwawasan luas, tapi juga memberi makna. Suasana belajar yang penuh motivasi dan prestasi membuatku makin yakin, inilah aku dan inspirasiku.
Di sini, kamu ditempa menjadi pribadi hebat dan bermanfaat.
Di sini, aku hadir bersama mimpi-mimpiku, melangkah satu demi satu untuk masa depan. Suasana Malang Raya yang sejuk dan nyaman menjadi tempat yang sempurna untuk belajar, berproses, dan menempa diri. Siapapun akan jatuh hati pada kota ini. Impian para pelajar dari berbagai budaya dan negara. Universitas Muhammadiyah Malang diberkahi puja-puji keindahan alam. Kampus ini penuh prestasi, tak heran pengakuan dari berbagai lembaga baik di tingkat nasional maupun internasional, tak henti-hentinya diraih. Mulai dari akreditasi institusi dengan nilai A dari BAN PT, hingga anugerah kampus unggul dari Dikti Wilayah 7 Jawa Timur sebagai kampus paling unggul 11 kali berturut-turut. Di tingkat global, tak kalah hebatnya, UMM 2 kali meraih ASEAN Energy Award, apalagi pada tahun 2010 sampai 2011, UMM juga mendapat predikat bintang 2 dari lembaga bereputasi internasional QS Stars World University Ranking. UMM juga sudah menjadi Associate Member AUNQA, Asosiasi Universitas ASEAN. Mahasiswa UMM sangat beragam. Mereka berasal dari berbagai penjuru tanah air dan mancanegara. Ada 11 fakultas dan 57 program studi yang dimiliki UMM, mulai dari diploma, sarjana, hingga master, dan doktor. Bahkan sudah ada 4 program studi yang terakreditasi dan tersertifikasi internasional oleh AUNQA. Pilihan program dan program studi yang ada di kampus ini seperti Fakultas Agama Islam, Fakultas Ilmu Sosial dan Ilmu Politik, Fakultas Keguruan dan Ilmu Pendidikan, Fakultas Pertanian dan Peternakan, Fakultas Hukum, Fakultas Psikologi, Fakultas Teknik, Fakultas Kedokteran, Fakultas Ilmu Kesehatan, Fakultas Ekonomi dan Bisnis, Program Magister, dan Doktor. Setiap fakultas dan program studi punya sarana laboratorium yang sangat lengkap. Semuanya terpusat dengan Laboratorium Sentral UMM. Laboratoriumnya juga sudah teruji karena telah meraih ISO dari Komite Akreditasi Nasional atau KAN dan berkualifikasi melakukan uji laboratorium untuk pihak luar, baik perusahaan maupun perguruan tinggi lain. Selain fasilitas akademik, UMN juga punya banyak unit usaha yang bisa menjadi income center bagi universitas. Berkat unit-unit usaha itulah, biaya operasional kampus tak hanya tergantung pada dana dari mahasiswa saja. Ada UMM Dom, UMM Hospital, Rumah Sakit Surya Medika Sumbawa, SPBU UMM, bengkel motor dan mobil UMM, Micro Hydro Power Plant, Apartemen Sang Surya UMM, BPR Rinjani UMM, Pusat Produksi Pertanian UMM Farm, Taman Rekreasi Sengkaling UMM, Rayz Hotel UMM, serta Kapal Garden Hotel UMM. Semua unit usaha ini juga jadi laboratorium terapan, sehingga iklim kewirausahaan mahasiswa jadi lebih terasa. Reputasi internasional juga menjadi salah satu kebanggaan kampus ini. Ada banyak kerjasama internasional yang rutin dilakukan UMM, seminar, konferensi, penelitian, hingga pertukaran mahasiswa, staf, dan dosen dengan banyak sekali universitas dan lembaga dari luar negeri. Sampai saat ini ada 111 perguruan tinggi maupun lembaga pemerintah dan non-pemerintah dari 31 negara di dunia yang telah berkolaborasi dengan UMM. Di antaranya yaitu konsorsium 22 universitas di Australia melalui The Australian Consortium for In-Country Indonesian Studies, konsorsium 33 universitas di Asia dan Eropa dalam program Erasmus Plus Komisi Uni Eropa, US Peace Corps, Akademi Al-Haramain Saudi Arabia, Korea Energy Economics Institute, Kemko Korea, Temasek Foundation, Confucius Institute Tiongkok, juga Sakura Foundation Jepang. Mahasiswa dan dosen UMM juga terbiasa kreatif dalam mengembangkan riset dan berkarya untuk pengabdian masyarakat. Semangat berkarya dan berkreasi ini menjadi motivasi mahasiswa ilmu komunikasi UMM sehingga berhasil menyulap Kampung Kumuh Jodipan menjadi kawasan kampung warna-warni yang terkenal hingga ke mancanegara. Juga Kampung Hijau Tempenosaurus di Desa Beji yang memperoleh pengakuan dari Museum Rekor Indonesia, MURI. Hebatnya lagi, selama 3 kali beruntun, tim robotik mahasiswa UMM memenangkan kontes robot internasional di Amerika Serikat. UMM juga dikenal sebagai kampus mandiri energi. Lebih dari 1 dekade lalu, UMM sudah memiliki pembangkit listrik tenaga mikrohidro atau PLTMH. Karena sukses diterapkan di kampus, konsep ini kemudian diaplikasikan lebih luas dengan membangun PLTMH Sumber Maron di Desa Karangsuko, Kabupaten Malang, dan kawasan wisata Bunpring. Program ini sukses membuat lebih dari 4.000 sambungan listrik terpasang ke rumah warga. Sukses berawal dari keberanian bermimpi dan melangkah untuk perubahan. Langkah kakimu hari ini akan menentukan kiprahmu di masa depan. Menjadi mahasiswa yang siap berkarya dan mengabdi bagi bangsa. Students today, leaders tomorrow.
University of Muhammadiyah Malang, UMM, is a campus with an international reputation. Provides an opportunity for all citizens of the world to get to know Indonesia. Through traditional dances, UMM innovates Indonesian culture from the 34 provinces. Having many philosophical values, UMM brings the international students learning Indonesian culture through traditional foods. Benteng, Jongklak, Gobak Sodor are a series of traditional games that become media for UMM to introduce positive characters. Welcome to UMM. Welcome to Indonesia.
University of Muhammadiyah Malang UMM is a private university sitting on a plateau of East Java in the city called Malang. The city is well known as a city of education, tourism and industry. Founded in 1964, UMM has now settled 3 campuses, namely Campus 1, Campus 2 and Campus 3. Devoted to environmental sustainability, UMM brings about a green and clean concept of campus. The concept is a vivid attempt to establish a vigorous, pure, and convenient atmosphere to boost creativity and productivity. UMM is also committed to open more green spaces by growing a variety of trees and flowers in every corner of the campus. UMM has achieved an outstanding acknowledgement from many associations, one of which is from National Board for Higher Education Accreditation for institutional accreditation with band A. In addition, UMM was awarded the Most Excellent Campus for the category of University in 2008-2016 by Cooperative 7 of East Java. UMM received international acceptance as it attained Asian Energy Award in 2009 and 2-star predicate from QS Stars World University Rankings in 2010-2011. UMM has also been an associate member of ONQA that is centered in Bangkok. The UMM Laboratory has successfully achieved the accreditation of ISO 9001 and ISO 17025 in 2008 from the National Accreditation Committee. UMM students come from any part of the nation and other countries. The students are the inspired generations that aim to excel in their programs of undergraduate and postgraduate studies. UMM's 10 faculties over 56 study programs. Each faculty is equipped with a comprehensive laboratory that is located in the Central Laboratory of UMM. The Central Laboratory has been qualified to conduct laboratory testing for either external, company or other universities' users. The Faculty of Islamic Studies, the Faculty of Teacher Training and Education, the Faculty of Political and Social Sciences, Faculty of Law, the Faculty of Economics and Business, Faculty of Psychology, the Faculty of Agriculture and Animal Sciences, the Faculty of Engineering, the Faculty of Medical Science, the Faculty of Health Science, Directorate of Postgraduate Program, The learning activities of UMM are monitored through a mechanism to guarantee the sustainability of a qualified higher education that is supported by representative facilities, such as library, mosque, student center, student dormitory, reading corner, information technology, meeting hall, theater, canteen, campus lake, and sport amenities. To add, UMM has also set up several business units, namely UMM Inn, UMM Dome, UMM Bookstore, UMM Hospital, UMM Gas Station, UMM Garage, Micro Hydropower Plant, Sang Surya UMM Apartment, UMM Farm Center, and Singkaling Tourism Spot. The facilities are the income center used to uphold the university operational expense in order to minimize the dependency from student admission fee. The business units might be possible to be an applied laboratory for students and can also help to create entrepreneurship. With a great enthusiasm to become a leading university with international credit, UMM has actively encouraged all campus elements to allow international partnerships. There have been notable MOUs made with international stakeholders in study program, faculty, and university level. UMM has as well regularly organized international conferences and seminars in collaboration with some abroad universities. Among others are consortium of 22 universities in Australia, an Australian Consortium for In-Country Indonesian Studies, consortium of 33 universities in Asia and Europe in Erasmus Mundus and Erasmus Plus European Commission, Peace Corps, BGP Dutch Engineer, Al-Haramain Academy of Saudi Arabia, Korean Energy Economic Institute, Chemco Korea, Temasek International Foundation, Confucius Institute of China, Sakura Foundation, and any other representatives of neighbor countries. UMM is challenged to synergize the human resources that are high in diversity by student coaching program. The programs are designed to upgrade the students' potential, skill, and characteristics. In early college period, students must participate in a program of shaping the characteristics and leadership. Devoted to nation, UMM has started to introduce a pattern of campus self-contained energy for the last 10 years by setting up a micro hydropower plant. The pattern was then implemented more widely to construct micro hydropower plants of Sumber Maro and Karangsuko Village, Malang Regency, in cooperation between the Faculty of Engineering of UMM and Sumber Maro Foundation in 2009. Today, with sufficient support of electricity, there are more than 4,000 water pipe connections installed in the neighborhood. In 2016, UMM has transformed a slum village into a tourism village named Jodipan, a village of colors. The program was performed by the students of Communication Science Study Program in cooperation with Indana Paint. This change has manifested a positive impact in a way that the villagers can now maintain their area cleanliness as well can improve their economic condition due to the increasing number of people's visits. At present, Jodipan is a new icon of Malang City. Since 2006, UMM has actively been involved in the revitalization of protected forests and national conservation of Bromo Tengger Semeru in partnership with PT Toyota Boshoku through JIFPRO, Japan International Forestry Promotion and Cooperation Center. The revitalized area, with the participation of students, lecturers, and local community, has now been 165 hectares wide. UMM always performs dedication for the nation, carries out energy with devotion for the sake of the progress and prosperity of Indonesia. UMM, from Muhammadiyah for the nation.
Fakultas Hukum Universitas Muhammadiyah Malang merupakan salah satu fakultas tertua di Universitas Muhammadiyah Malang. Dalam perkembangannya, sebagai penyelenggara pendidikan hukum, Fakultas Hukum Universitas Muhammadiyah Malang tidak hanya memberikan teori kepada mahasiswa, akan tetapi juga menempa mahasiswa dengan berbagai praktikum mata kuliah, pendidikan latihan, dan kemahiran hukum, serta memberikan kesempatan magang bagi mahasiswa, baik wilayah regional Jawa Timur maupun di tingkat nasional. Hal ini sebagai upaya Fakultas Hukum UMM dalam membekali mahasiswa agar mampu bersaing secara nasional maupun global. Kebijakan pimpinan universitas yang secara progresif mengembangkan konsep UMM pasti dalam merespon perkembangan dunia pendidikan tinggi juga sangat selaras dengan visi Fakultas Hukum untuk mewujudkan sarjana hukum yang profesional, humanis, dan religius.
Assalamualaikum warahmatullahi wabarakatuh. Saya Dr. Tongat SHM Hum, Dekan Fakultas Hukum Universitas Muhammadiyah Malang. Dalam rangka merespon dan menghadapi tantangan global yang kian sengit, Fakultas Hukum Universitas Muhammadiyah Malang mengukuhkan eksistensinya melalui visinya, yaitu menjadikan Fakultas Hukum yang terkemuka dalam penyelenggaraan pendidikan tinggi hukum yang berkeunggulan di bidang penguasaan dan penerapan ilmu hukum untuk menghasilkan sarjana hukum yang profesional, humanis, dan religius. Berbagai upaya pengembangan Fakultas Hukum Universitas Muhammadiyah Malang diorientasikan juga untuk mewujudkan konsep UMM pasti, yaitu pasti lulus dan pasti kerja.
Fakultas Hukum UMM memberikan kesempatan kepada alumni untuk mengembangkan keilmuannya dengan memberikan pelayanan kepada masyarakat di Pos Bakum Pengadilan Agama Kabupaten Malang. Fakultas Hukum juga mampu menghasilkan alumni yang tangguh dan dapat bersaing di dunia global.
Assalamualaikum warahmatullahi wabarakatuh. Saya Komisaris Polisi Sunardi Riono, jabatan sehari-hari Kepala Bagian Operasional Polres Malang. Saya bangga menjadi alumni UMM. Saya angkatan 1987. Apalagi dengan perkembangan UMM yang sekarang ini, sudah pasti saya merasa bangga saya sebagai alumni UMM atau Universitas Muhammadiyah Malang. Sesungguhnya saya ingin banyak berkontribusi kepada alma mater, karena banyak sekali sesungguhnya kejadian-kejadian atau permasalahan hukum yang saya temukan di masyarakat yang seharusnya bisa dikembangkan melalui riset, melalui seminar dan lain sebagainya di dunia perguruan tinggi. Insya Allah apabila ada mahasiswa yang membutuhkan untuk penelitian dan sebagainya, saya siap untuk membantu. Terima kasih Fakultas Hukum UMM. Wassalamualaikum warahmatullahi wabarakatuh.
Banyak prestasi akademik yang ditorehkan mahasiswa Fakultas Hukum, diantaranya juara debat konstitusi, baik di tingkat regional maupun nasional, serta berbagai prestasi lainnya. Selain di bidang akademik, Fakultas Hukum UMM juga mendorong dan mendukung prestasi mahasiswa di bidang non-akademik, yaitu di bidang sepak bola.
Nama saya Bagas Dewi Caksono, mahasiswa Universitas Muhammadiyah Malang, dari Fakultas Hukum dan angkatan 2017 semester 4. Saya memilih Fakultas Hukum Universitas Muhammadiyah Malang seperti yang diketahui karena Fakultas Hukum Universitas Muhammadiyah Malang dan di sana banyak talenta-talenta pesepak bola yang sangat handal, dan saya memilih itu karena saya pribadi dan teman-teman tertarik atas sepak bola sebagai hobi saya dan pekerjaan saya, dan ingin menjunjung tinggi nama Universitas Muhammadiyah Malang. Terima kasih Fakultas Hukum Universitas Muhammadiyah Malang. Salam sejahtera, salam olahraga. Wassalamualaikum warahmatullahi wabarakatuh.
Saat ini, Fakultas Hukum UMM menjadi salah satu fakultas yang menyelenggarakan pendidikan khusus profesi advokat yang bekerja sama dengan Peradi Kota Malang.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan saya Iwan Kuswardi, Ketua Dewan Pimpinan Cabang Peradi Malang Raya, yang selama ini sudah sering melakukan kerjasama dengan Fakultas Hukum Universitas Muhammadiyah Malang. Beberapa kerjasama yang kami lakukan membuahkan hasil yang sangat luar biasa. Bagi mahasiswa yang ingin praktek magang di Peradi Malang Raya, beberapa kali mereka juga sudah melakukan kegiatan-kegiatan bersama Peradi Malang Raya. Pada saat Peradi Malang Raya menginginkan satu inovasi, mereka memberikan satu inisiatif, yakni membentuk organisasi bantuan hukum atau yang biasa dikenal dengan LBH. Selamat buat Fakultas Hukum Universitas Muhammadiyah Malang. Wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum, nama saya Muhammadiyah mahasiswa Fakultas Hukum Angkatan 2017. Saya bangga menjadi mahasiswa Fakultas Hukum karena Fakultas Hukum UMM telah mengantongi akreditasi A dan juga dosennya pun memiliki keahlian yang sangat luar biasa.
Assalamualaikum, nama saya Devi Aprilia Salama. Saya dari Fakultas Hukum UMM Angkatan 2017. Saya bangga menjadi mahasiswa Fakultas Hukum UMM karena di sini saya diajarkan untuk mengasah skill selain di bidang akademik, juga di bidang non-akademik.
Assalamualaikum warahmatullahi wabarakatuh. Saya Rizky Nuzwantika, mahasiswa Fakultas Hukum Universitas Muhammadiyah Malang Angkatan 2017. Saya memilih Fakultas Hukum Universitas Muhammadiyah Malang karena di sini kita tidak hanya diajari tentang teori, melainkan prakteknya juga melalui program praktikum di mana tidak kita bisa dapatkan di Fakultas Hukum Universitas yang lain.
Assalamualaikum, saya Klavinova, mahasiswa Fakultas Hukum UMM 2017. Saya memilih FH UMM karena di sini saya diajarkan menjadi mahasiswa yang kreatif. Selain itu, di sini kita juga diajarkan menjadi mahasiswa yang profesional, humanis, dan religius.
We love FH UMM, justice for all.
Selfie. Guys, this is Malang and we are students of UMM.
Seseru apa sih kuliah di UMM?
Apalagi ya?
Pokoknya seru banget!
Wait, dari mana sih perjalananmu dimulai?
Dulu saya masuk jalur prestasi akademik.
Jalur prestasi minat bakat.
Aku jalur reguler dong. Berproses di kampus putih sama dengan berkomitmen untuk jadi yang terbaik. Tagline tidak ada prestasi yang tidak dihargai selalu digaungkan di tiap kesempatan. Udah banyak living proof dari tagline itu. Tim robotik UMM yang jadi juara di kontes internasional bisa bebas kritik. Penulis novel yang diangkat ke layar lebar pun bisa dapat kesempatan yang sama. Yang punya bisnis sukses bisa banget ambil peluang ini. Dan masih banyak mahasiswa berprestasi lainnya.
Bukan mahasiswanya aja yang punya banyak prestasi, kampusnya juga loh. Mulai dari akreditasi A dari BAN PT, raihan ASEAN Energy Award berkat komitmen UMM untuk jadi kampus hemat energi. Dan udah 13 kali berturut-turut loh, UMM jadi kampus swasta terunggul di Jawa Timur. Eits, jangan lupa, laboratorium sentral UMM terjamin mutunya. Laboratorium sentral UMM terjamin mutunya karena tersertifikasi ISO 9001 dan ISO 17025 dari Komite Akreditasi Nasional. Selain terakreditasi di tingkat nasional, program studinya pun mendapatkan rekognisi internasional loh dari lembaga sertifikasi ALM-QA dan IAB.
Terbaru, di tahun 2021, UMM raih prestasi tingkat internasional sebagai Universitas Islam terbaik dunia versi Unirank.
But I guarantee you, there's a lot more to come. Di UMM, atmosfer internasionalnya sangat terasa. Mahasiswa UMM bisa belajar bareng mahasiswa asing yang ikut program reguler, KMB, dan mahasiswa sampai belajar budaya dan bahasa Indonesia di DIPA. Pojok budaya internasional di UMM juga banyak, mulai dari American Corner, China Corner, Thai Corner, India Corner, dan Aussie banget Corner. UMM terkenal mendunia lewat KKN dan magang internasionalnya. Belum lagi, kerjasama internasionalnya sangat luas. Let's say, a collaboration with Temasek Foundation Singapore for Community Engagement in both countries. Confucius Institute China yang beri kesempatan lecture and student exchange. ACCIS Australia yang buka pintu lebar bagi pelajar Australia dalam sosial budaya Indonesia di UMM. Lanjut lagi ke kemitraan dengan Medcare Jepang yang memudahkan lulusan langsung kerja di Jepang. Last but not least, partnership with Erasmus+, sebuah organisasi konsorsium Uni Eropa yang beri peluang mahasiswa, staf, hingga dosen belajar di Eropa. And there's still many more.
Wow, keren banget! Proses perkuliahannya pun nggak kalah keren. Ada program UMM pasti yang ngejamin mahasiswa buat pasti lulus 4 tahun, pasti mandiri, dan pasti bekerja.
Cuman itu aja ya?
Ya enggak dong, pendidikan karakter benar-benar diperhatiin. Ada P2KK yang menjadi langkah awal untuk kehidupan kampus. Pas kuliah, wawasan keislaman terus biasa. Lewat kegiatan semarak, literasi Quran yang terintegrasi dengan mata kuliah Al-Islam dan Kemuhammadiyaan.
Kegiatan ini tentunya membentuk jiwa mahasiswa yang peduli kepada sekitar, utamanya masyarakat. Let's go! Social skills mahasiswa benar-benar ditempa. Ada kuliah kerja nyata, pengabdian masyarakat oleh mahasiswa, program pengembangan desa mitra atau PPDM, dan banyak lagi lainnya. Makasih ya Pak. Dosennya pun gak kalah berprestasi lah. Community engagement dilakukan lewat berbagai cara, mulai dari pembinaan desa wisata, pertanian, hingga kemitraan. Kelas praktikumnya sangat menantang, karena dosen beri tugas mahasiswa untuk cari real client and together they solve its client problem. Misalnya aja, kerjasama dengan Indana Paint untuk CSR di Kampung Warna-Warni Jodipan. Wujudkan Berakseng jadi tempat wisata yang viral, dan banyak deh.
Nah, gak hanya itu aja loh, UMM punya banyak laboratorium terapan. Ini jadi wadah mahasiswa untuk belajar dan menerapkan apa yang sudah dipelajari di kelas. Laboratorium terapannya mulai dari rumah sakit umum, Rayz Hotel UMM, Kapal Garden Hotel, Rooftop Resto and Cafe, Kamar Rekreasi Sengkaling, Bengkel Mobil Rinjani, SPBU UMM Energi, UMM Dome, Bank Syariah Bumi Rinjani, Pembangkit Listrik Tenaga Mikrohidro. Kesemua laboratorium terapan ini bakal memperkuat pengetahuan dan pengalaman mahasiswa.
So, what are you waiting for? Let's be one of the web campus students. Raih mimpi, prestasi, dan inspirasi.
Bapak Ibu, acara akan kita mulai dalam 5 menit. Dimohon kembali memasuki ruangan. Baik, untuk Bapak Ibu yang masih di luar, kami persilahkan untuk memasuki ruangan karena acara akan kita mulai tepat insya Allah pukul 3.30.
Tes. Belum Juli terlalu terkenal kan. Bisa dihubungi. Itu tambahan stok kontak di sebelah mana?
Oh, saya.
Katanya di depan sini.
Oh, di situ.
Wih, siap. Di sini. Loh. Lima 5715 5121. Oh, atur nuwun Mas.
Bapak Ibu, we are about to start the plenary sessions. So for Bapak Ibu, those who are still outside, please join with us today here. Assalamualaikum warahmatullahi wabarakatuh. I need your attention back. So assalamualaikum warahmatullahi wabarakatuh, Bapak Ibu. Hello. Good afternoon for both of you who join online also and offline here. So as I mentioned previously before the coffee break, now we are having the next sessions, which is plenary sessions. There will be 2 sessions, and both sessions are going to be moderated by Bapak Hasnan, who is now in front of you, the one with glasses, yeah, the most handsome one there, because we only have one Bapak and one Ibu on the stage. So Bapak Ibu, ladies and gentlemen, before we start the plenary session, let me read Pak Hasnan short bio. So Bapak Hasnan Bahtiar is Director of Research at the RBC Institute Abdul Malik Fajar. He is also the Executive Secretary at the UMM Human Resource Development Training Center. He is a lecturer at the Islamic Family Law Study Program, or here in UMM we call it as HKI, Bapak Ibu. So from the Faculty of Islamic Religion, and also he is the lecturer as well at Law Studies Program, definitely Faculty of Law, UMM. And in addition, he is also a member of the editorial board of ibtimes.id, which is a website that has consistently championed the idea of the rule of law and Islamic moderations in public. Bapak Bahtiar Hasnan Bahtiar, SHI, Master of Islam in Modern World Advance, such a long degree, Bapak, and title. He completed his first bachelor's degree in the field of Islamic legal philosophy and wrote a final project on Imam Shafi'i and doctrine of the public benefit in the Kitab Al-Risalah in 2009. And then he completed his second bachelor degree in the law of war and international relations at the Center of Arab and Islamic Studies, Middle East and Central Asia. And then the Australian National University, Australia. And submitted a thesis on, well, forgive me, Pak Hasnan, if I pronounce this incorrectly. This one is Dar al-Had, is it? Okay. Wa al-Shahadah, Muhammadiyah's contemporary ijtihad of Syiar and Pancasila. Well, actually, there are plenty of articles published on journals, but if I read them all, maybe I'll just finish this tomorrow, yeah? We have plenty of them. So, without further ado again, let's welcome our moderator who will handle 2 plenary sessions today. Let's have Bapak Hasnan Bahtiar handle the plenary sessions. Please, Bapak.
Thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much, especially for the chief of the committee of this distinguished forum of conference, my dear brother Salahuddin Al-Fatih, and my dear sister Holida, for the invitation to engage with the 3rd INCLAR of the Faculty of Law 2022. And with us today is the Dean of the Faculty of Law, UMM, Professor Dr. Tongat, and many other friends and colleagues and presenters of the conference. Ladies and gentlemen, thank you for coming at this 3rd INCLAR. And due to the big issue that we will undertake is understanding law reform on post-COVID-19 pandemic, this conference will discuss various topics at this plenary session. And as mentioned before by moderator, the session will be divided into two parts. And the first part is running now and will be end at 7 o'clock p.m. Jakarta or Bangkok time. And the second session will be held at 19 o'clock to 20:30 p.m. Each of us speakers technically will have only 15 minutes to deliver a presentation. I repeat again, each speaker will have 15 minutes for delivering a presentation, and the rest of the time we will have Q&A. And we have now 3 speakers. I'd like to introduce you all the speakers. The first is my dear sister, big sister, Juli Satya Pratiwi. She is a PhD candidate of the Institute of Human Rights and Peace Studies at Mahidol University, Thailand. She holds a Master of Laws from the School of Law, Utrecht University, the Netherlands, and a Master of Comparative Law of Joshua Reuben Clark, Brigham Young University, the United States of America. She is a senior lecturer at Law Faculty and a chairwoman of the Center for Civilization and Human Dignity Studies of UMM. And since 2022, this year, she is a General Secretary of Indonesia's Human Rights Lecturers Consortium for the period of 2021 to 2026. Ladies and gentlemen, she has been invited as a speaker at various international and national conferences. She has engaged as a trainer and an organizer of the annual program of the master level course on Sharia and human rights arranged by the Center for the Study of Religion and Multiculturalism, PUSAM UMM, collaborated with the ICLRS USA, the International Center for Law and Religion Studies, and the Oslo Coalition on Human Rights, Norway, and participated at a training program of religion and the rule of law in Myanmar, Vietnam, Beijing, USA, and Jakarta. Her current works are religious freedom in Indonesia using UPR approach, 2020, and the root causes of hate speech in Malaysia, worked with Article 19, London, 2019 to 2021. Analysis of the appeal of IET law funded by Komnas HAM this year. And the last but not least, a policy strategy for the protection of Indonesia tribal peoples funded by the Ministry of Foreign Affairs of the Republic of Indonesia, 2022. Her most recent publications are Rethinking the Constitutionality of Flawed Indonesia's Anti-Blasphemy Law, and then Blasphemy Law as a Structural Violence, a Challenge for Maintaining Sustainable Peace, 2021, and then Bridging the Gap Between Cultural Relativism and Universality of Human Rights, Indonesia Attitudes, 2020, Indonesia's legal policies amid COVID-19, balancing religious freedom and public health, forthcoming. And the last but not least, critics on contemporary discourse of international human rights law, a global south perspective, human rights in global south, forthcoming. Ladies and gentlemen, the second speaker is Dr. Noor Anita Abdullah. She is an associate professor of the School of Law, University Utara, Malaysia. She is currently a research fellow at the Legal and Justice Research Center under the Center of Excellence, COE, of University Utara, Malaysia, which is focusing on research and consultation. She graduated with the Bachelor of Laws with honors 2003 and Master of Comparative Law 2004 at International Islamic University of Malaysia, IIUM, and a PhD holder from University Kebangsaan Malaysia in 2013. She started her career as a schooler in 2005 at a private college and university before joining UUM in 2006 as a tutor. She also had early completed her pupillage in 2005 from Messrs. Wan Harun Hasim, Kota Baru, Kelantan, a legal firm, before joining her career as an academic to obtain her qualification as an advocate and a solicitor. She wrote a PhD thesis on the threat of bioterrorism towards public health and security in Malaysia, a socio-legal study. Her study is mainly focusing on public health and security laws, bioterrorism law, and commercial laws. Furthermore, she has collaborated actively with scholars from other disciplines. Currently, instead of focusing on research and publications, she begins her further interest in innovation in relation to legal field by joining in innovation and commercial conferences and competition in responding to the university's need to diversify the involvement and research fields. The most current her publications are Political Socialization of Malaysian University Students, 6 Legal and Ethical Perspectives, 20 and 21, Safeguarding the Rights and Welfare of the Healthcare Workers Amid the Pandemic, a Social Protection Approach, 20 and 21, Bilateral Investment Treaties and the Increase in Egyptian appearances before International Arbitration Tribunals, 20 and 21. And the third speaker will be Dr. Olivier Faure. Is an associate professor in the Faculty of Law, Northwest University, South Africa. He obtained his LLB degree, second class upper division honors, in 2002 from the University of Buea in Cameroon. And in 2009 and 2014, he respectively obtained his Master of Laws and the Doctor of Laws from the NWU. He was a postdoctoral fellow at the same university in 2014 and a senior lecturer at the University of the Free State in 2015. Olivier Faure is a recipient of several fellowships, including the TWAS DFG Cooperation Visit Programs for Scientists from Sub-Saharan Africa, the Humboldt Talent Travel Award, and a DAED scholarship that enabled him to visit the Faculty of Law, Freie Universität Berlin, Germany, on several occasions, and the Justus Liebig University occasion in 2013. Olivier Faure serves as a reviewer for several law journals and is assistant editor of the Ponsef's Room Electronic Law Journal. His research primarily focuses on the role of local government in advancing the constitutional ideal of social justice in South Africa. Olivier Faure has presented papers in national and international conferences and has published numerous articles in established national and international journals. His current academic works are a comparative legal analysis of urban climate mitigation and adaptation in the building sector in Brazil, Germany, and South Africa, 2022. And the second is rethinking the regulation of university students' protests in light of Lungwana versus the state, 2018, ACC 45, 2020. And then nativism in South African municipal indigenous policies through a human rights lens, 2020. And then Dr. Herwastuti, she obtained her PhD degree from the Faculty of Law, the University of 11 Maret, Surakarta, master's degree on Sociological Studies from the Postgraduate School of the University of Muhammadiyah Malang, and Bachelor of Laws from the Faculty of Law, the Brawijaya University. All these universities in Indonesia, she has a specialization in the private law, commercial law, and business law, and the banking disputes in Indonesia. She has actively participated in various academic forums as a speaker, and the most importantly, she has contributed to the process of making law in the House Representatives of the Republic of Indonesia, DPR RI, especially when dealing with the discussion on the draft of law on the renewable energy in Indonesia. Her roles are significant for the state, and she has contributed to several levels of the state institutions, from regional to national. Her academic publications are outstanding. Her current works are reconstruction of consumer protection in the banking sectors, making the legal perfection of the substantive justice, 2018, and then the reconstruction of the settlement of banking dispute, 2019, and the reconstruction of the taking off agreement of the house ownership, the perspective of the legal certainty, 2020, and the last but not least, business competition, cartelization, and the cases of law in Indonesia, 20 and 21. And then we have Fernando Arletas. Himself is a professor of international relations at the Zaragoza Defense University Center. He obtained his Bachelor of Laws, Master of Laws, and doctoral degree in Legal Sociology and Political Institution from the University of Zaragoza. He was a postdoctoral researcher at Centre d'études de recherche internationale communautaire, l'Université de Marseille. In addition, he has extraordinary scholarly experience in various institutions in the world, such as the CONICET, Argentina Research Council, Universidad de Buenos Aires, kemudian, and then the Universidad Externado de Colombia, and Universidad Nacional Autónoma de Mexico, and École Normale Supérieure de Garçons, and Universidad Católica Argentina, and Université Claude Bernard Lyon. He has a specialization in international human rights law, relations between law, state, and religion, and international migration. He has also various academic works, such as prevention and repair of environmental damage, theoretical problems in Argentine perspective, 20 and 22. Nature and scope of asylum in the inter-American human rights system, 2016, and state neutrality and legal status of religious groups in the European Courts of Human Rights case law. Ladies and gentlemen, then I'd like to invite the first speaker, Dr. Juli Satya Prativi, who will deliver her paper on law reform in Indonesia, human rights and setbacks. Please, Dr. Juli, 15 minutes.
Thank you, Moderator. His Excellency, Dean of Law Faculty, University of Muhammadiyah Malang. Good afternoon, ladies and gentlemen. The distinguished speakers, all participants, and the committee of the conference. First of all, I would like to say thank you to having me today. And this is such an honor for me to be invited and to speak in front of you, because I believe that all of you are the experts in your field. Therefore, actually, I also want to learn from all of you as well. So, without overdue, let me start my presentation with tell me a little bit about the title of my presentation today. Law reforms in Indonesia, human rights setbacks. I know that this title is quite straightforward, but let me explain why I choose this title. Next, please. Next slide, please. Yes, thank you. So, law reforms means the modification of the law through the elimination of defects. And in this study, what I mean as the law reforms in relation to human rights is that we want that Indonesian legal system or national law to be compatible with the international human rights standard. The question is, why do we need to make our national law comply to the international human rights standard? It is because since the beginning of the establishment of the country, our founding fathers clearly stated in the 1945 Constitution of Indonesia that this country is based on the rule of law and want to develop democracy. As we know that the characteristic of a democracy country is respecting human rights. And moreover, Indonesia is also one of the United Nations member, and as the member of United Nations, we obliged to do what mentioned in the United Nations Charter. If we look at the Article 3 of the United Nations Charter, all members of United Nations must respect the human right of its all citizens. And moreover, when we learn from the past experience, we don't want to set back to the authoritarian governments such as what we experienced during the New Order. The regime when the human rights was degraded, the regime when the law was so much politicized. So, yeah. At the beginning of the Reformation era, we knew that the spirit to respect and protect human rights was, I would say, on the top. However, when we compare to what we experience today during post-Reformation era, or you can say during the COVID-19 era, I think we are facing the era of human rights setbacks. Why I say that? There is some indication on it. First, global and economy reports that the human rights and the rule of law index in Indonesia is declined from 7.4 in 2016, become 6.4 in 2021. And the second, according to Herlambang, one leading scholars in Indonesia who are also expert in human rights, there is such indication of the autocratic legalism. Why? Because law in Indonesia is subordinated to political interests. Third, referring from the study done by Argama in 2014 to October 2018, Indonesia enacted around 8,945 new regulations. This is such a hyper number of regulation, I would say, but each of them, very often contradictive each other. And fourth, I observed in the study that legislation products between 2014 to 2020 did not demonstrate the lawmakers' support towards human rights. And I will elaborate more this point. So from this background that I explained before, I would like to focusing on answering three research questions. But if the time is not, it's limited, then maybe I will address two questions. So the first question is why law reform demands justice and human rights protection. And the second, why does the current law reform in Indonesia represent the decline in human rights? And the third, why Indonesia lawmakers hesitate to comply with the international human rights law. So next slide, please. Next slide, please. Yes, thank you. So to answer the first question, I want to elaborate 3 points. So first, I argue that the rule of law demands justice and respects human rights. I cited from what Alf Ross said that justice presents when the application of law is correct. In contrary, if the law is unpredictable and uncertain, then you never know what is going on. Why people are arrested, why others are not. Why people is found guilty for do nothing wrong, and etc., etc. Second, I believe that if we do ignore a human right, then no justice present. According to Bodenheimer, justice demands freedom, equality, and other basic rights. We want our human rights are respected by the state. Therefore, we need the law guarantee our human right. No matter what our religion is, our skin color, our gender, our economic status, we want the government treat everyone equal and according to the law. So we don't want ourselves or our family or our friends and colleagues to be treated cruelly by anyone, including by the state apparatus. This is what Brian Harry emphasized as the element of necessary of law reform. The law is the law that enacted by the lawmakers should be achieve complete and utter justice, namely equality before the law, enforce ideals of democracy, and an absence of arbitrariness. So next slide, please. Next slide, please. Yeah, so moreover, in order to accomplish the utter justice, Indonesia obliged to make its national law compatible with the international human rights law laid down in the Universal Declaration of Human Rights and its derivative treaties. Indonesia at least has 3 obligations towards human rights: obligation to respect, obligation to protect, and obligation to fulfill human right. For every individual living in the Indonesia jurisdiction, it is no doubt that Indonesia has ratified 8 out of 9 of the human right treaties. However, ratification is not enough. According to Posner, in his book titled The Twilight of International Human Rights Law, says that the high number of ratification is not always guarantee that the country fully respect human rights. Human rights violations still found in the high number in the country that ratified international human rights treaties. Therefore, it is important to make sure that international human rights law is fully adopted in our national and local law through legislation or maybe through judicial review. Next, please. Next slide, please. Yeah. However, in the context of Indonesia, I found in this study that lawmakers allow human rights principle degrade. Why? Because in the lawmaking process, the lawmakers leave human rights principle and norm untouched. It is very often that during the lawmaking process, the lawmakers discuss unnecessary things. For instance, the legislation products between 2009 and 2020 did not demonstrate the lawmakers' support towards human rights protection. There were only a few laws that made to strengthen human rights fulfillment. I found that no indicator to measure whether the laws follow human rights standard or not. And I noticed that there is a national standard and procedure of human rights made and provided by the National Commission of Human Rights, but it's never followed by lawmakers, unfortunately. So as the result, many laws weaken human rights. Various bills raise public criticism and protests, of course. We can see in the media almost every day. And various laws have been reviewed in the Constitutional Court of Republic Indonesia. Okay, so next please. And the bills continue to threatening the right to freedom. I give you example. One is the bill of the second amendment of the IT law. Yeah, we see that several articles still found multi-interpretation and incompatible with international human rights law. Sometimes we don't know the difference between hate speech and blasphemy and defamation, and no articles, regulates about the standard limitation of freedom of religions. We believe that, we understand that freedom of religion is not absolute right, but to limit freedom of religion must be based on the law and must be have a necessary aim, to protect, for example, national interests, to protect the right of others. And then the third standard is that the limitation must be, not on the basis of discriminate others. But those standard limitation is not there. So that's why we think that, this bill is still problematic. And the second example is the bill of the criminal code. We know that, so we discuss a lot in many events and many discussions. And one of the article that I observe here is the article about defamation, as I mentioned before, because this two bill is actually, the bill of the criminal court want to change the bill of IET. So when we already ratified, for example, the bill of the criminal court, then we don't necessarily to discuss about the bill of the IT, because they discuss the similar articles. Yeah. Next, please. Yeah. To make it more shorter, this is I able to address the third question. So my question is, why lawmakers delay the reform of the outdated law? This is another example of the failure of the lawmakers to comply international human rights standard. This is one of my research as well. So sometimes we found that Constitutional Court is also ambiguous when reviewing the law. This is one example. So in this decision, the Constitutional Court of Republik Indonesia state that the law is constitutional at one hand, but in the other hand, or at the same time, the court acknowledged that the formal and material aspect of the law need to be revised to avoid multi-interpretation. So the Constitutional Court ambiguous decision caused that the anti-blasphemy law to remind the legal basis for punishing and violating the rights of religious minorities, and lawmakers continue to delay amending this law. Yeah. And the last slide, please. I think this is my last. why lawmakers hesitate to comply with the international human rights law? I found that first, the Universal Declaration and its derived covenants are common minimum standard in the protection of human rights. But legislators and human rights protectors such as Constitutional Court of Republik Indonesia often refer the other standard.
1 minute left. 1 minute.
1 minute, okay. Yeah, I think I can minutes. Yeah, thank you. Such as ASEAN values or local values. I have a paper that discuss more about this. If you're interested, I can share to you. And the second article 20J of the 1945 Constitution is often interpreted narrowly and incorrectly to justify all forms of human rights restriction, no matter if the human right is absolute. So they, some lawmakers or bureaucrats say that all human rights are possible to be limited, but actually there are some human rights are absolute. Yeah, and it is because the Constitution does not regulate indicator of legal and proportional limitation on human rights. And the third, Indonesian ratification of various international human rights treaties has not been seen as an obligation to fully realize its contents, but only in the interest of enhancing its international image. So we love to ratify international treaties because we want other countries see that Indonesia is the country who respects human rights, just for image, the pencitraan. Yeah. And the lawmakers' lack of comprehensive understanding of human rights, so they do not realize that human rights violation is one aspect will have impact on human rights violation in other aspects. So mostly they don't understand about that. Misunderstanding towards human rights lead to maintain impunity so much. We know that there is so much black campaigns against human rights, such as, oh, human rights is Western products, human rights is not our culture, human rights is incompatible with Sharia law, etc., etc. So this is my presentation today. Thank you very much for your kind attention. If you have any comments or questions, please feel free to deliver, and thank you very much.
Thank you, Dr. Chakli Pratiwi. Ladies and gentlemen, the concluding remarks that can be seen from the Dr. Chakli's presentation are the first is that the legal reform in the country seems to continue to fail to achieve justice, right? And then as a consequence, it tends to lead difficulties in dealing with the process of democratization in the country if human rights law is ignored. So the legal prescription that is possible, that might be possible to solve the problem is that the lawmakers of the country should not deny the importance of the human rights law. And then, ladies and gentlemen, I'd like to move to Dr. Nur Anita Abdullah. Assalamualaikum, Doctor.
Waalaikumsalam. Can you hear me well?
Yes, it's great. Dr. Nur Anita Abdullah's presentation is about Malaysian health legal response towards COVID-19 outbreak. Dr. Nur Anita Abdullah, the time and screen are yours. Please.
So, share my screen first. Okay, can you see the slide? Okay.
Perfect.
Okay. Assalamualaikum and a very good afternoon. As what has been mentioned by our chairperson just now, my name is Nur Anita binti Abdullah from School of Law, University Utara Malaysia, coming from Malaysia to Indonesia. Okay, Alhamdulillah, first I thank you very much for the invitation, having me today as one of the speakers, among the speakers. Okay, my topics today is regarding the health legal response to COVID-19 outbreak from the Malaysian perception. Okay, I think this phenomenon is considered common to everyone, especially the worldwide, involving Indonesia, the South African, and everywhere in the country, in the world. It was considered as an issue that time. Because that time when it happened, the outbreak happened, so we are thinking about the measure, what should and should not be taken. So in that particular process, the most important thing is in order to prevent the spread of transmission, because we don't know what will happen. We don't know what is COVID. We just knew COVID at that particular time in 2020. At that particular time, there was no vaccine, there was nothing. That is, we don't know how to cure it. And of course, it needs a special attention. It needs a special treatment for us, especially for the public. So of course, in order to have this kind of a treatment and the facility whatsoever, the government need to take action on it. And of course, it needs a legal response, especially in the public house. Okay, I think everyone's aware that we are in the collaboration with the WHO, World Health Organization, and of course we do have the IHR. Like Lee mentioned just now, the IHR, but I understood the International Human Rights, right? But for my perception, it's International Health Regulation. So we do have the IHR 2005. So the implementation or the measure takers, of course, we have to refer to the WHO as well as the IHR 2005 as well. If you can see here, is one of the articles that I quoted, Article 43. Restrict the measure countries can implement when addressing public health risks. So I just want to relate with the speech given by Ms. Chetty just now regarding the human rights. So I think that the Article 43 is actually restrict the measure in order to avoid the human rights, because they want to focus, because they don't want to take measure that can do something to the human rights. But somehow, in order to prevent the spread of the disease, we need to implement something. So how? So the question is how? We want to implement a measure, legal measure, in order to protect people, but at the same time, we have to protect the human rights. So this is the question that I think until today, it is still a question, because we don't know how to protect human rights. At the same time, we want to prevent the spreadness of the disease. Okay. I don't want to focus on the IHR because you are giving me only 50 minutes. Okay, so now we are focused on Malaysia. Okay, one of the public health response, especially the legal health response. Okay, everyone knows regarding the vaccination. I don't know what happened in Indonesia, but in Malaysia, of course, even though it is not compulsory for us to be vaccinated, it is not compulsory, it is not mandatory for us to be vaccinated, but we do being vaccinated 3 times. The first dose, the second dose, as well as the booster, that one is the third dose. Okay, so however, so we do have a legal requirements and procedure because we cannot produce our own. Malaysia cannot produce our own, so we have to import. We have to import the vaccine from outside Malaysia. But these are the requirement, the legal requirement that Malaysia has to follow in order to import the vaccine from outside Malaysia. And in Malaysia, we have the Control of Drug and Cosmetic Regulation, and under the CDCR, so we do have 2 acts in regulating the importation of vaccination, which is known as DCA, Drug Control Authority, as well as Sale of Drug Act. Why do we have to refer to these 2 statutes or these 2 acts? Because in order to the importation of vaccination to be registered, in order to have a QCI or quality control inspection, in order for the vaccination to be licensing, and when they are registered, the vaccine being registered in Malaysia, at least we are confident with it, even though we do believe that not all people believed to the vaccines. But somehow these are the process that Malaysian government need to take into consideration in order to ensure the quality, safety and efficacy of the medicinal product that we import from abroad. Okay, as I mentioned to you just now, why do we have to have this kind of legal requirement? As what we know that vaccine is a product. So when we consider it as a product.
Excuse me, doctor.
Yes.
Did you already move the slide?
Yes.
Oh. Because it seems, yeah.
I already moved my slide to. Yes, I can see from
the
here.
screen, right? Yeah.
My slide is not. I don't know what happened.
Will you please do restating it?
Reset.
I mean, just.
I just.
Yeah, share the screen again. Yeah. Oh yeah, that's moving.
Okay,
yeah,
that's okay.
Get it. Thank you.
I think I went. I already make it one. Okay.
Okay.
It is not larger in the screen.
Oh.
I can see it from the screen. So can I just make it small? Because I can see from there.
Oh yeah.
Okay. So can I continue?
Yes, please.
Okay. As I mentioned to you just now, why do we have to follow all the legal requirements in order to import all the vaccination? So these are the process. Vaccine is a drug, and of course it is a product, and it is used for a medical purpose. So we do have to follow all these legal requirements in order to consider our public health concern, especially in Malaysia. But I believe also in Indonesia, they do have the same legal measure taken as well. And from these kind of legal requirements, of course, COVID-19 is a very urgent matter. We consider it's an urgent matter because we are in need. So that's why one of the steps to be taken, registration purposes, it is a must. So any importations of vaccine, it need to be registered, but somehow because it is an urgent, so we consider it as an exceptional cases. So we consider no need to be registered first. But of course, the other steps, for example, like vaccine lot release, licensing, storage, and transportation, so these steps needs to be considered in order to ensure the safety and the safeness of the use of that kind of vaccine to us as a public citizen in Malaysia. And I don't want to mention everything regarding the pros and cons regarding the vaccination, because we have those who accept vaccine and those who are anti-vaccine. I think all people in all countries in the world have this kind of two perception. I believe that too. So that's why I believe that why vaccination is not made mandatory in Malaysia. I don't know what happened in Indonesia, whether you are considered is mandatory or not. But in Malaysia, it is not made mandatory. But somehow, in order to go through some process in Malaysia, you have to be vaccinated. Even though it is not made compulsory according to the law, but some process you need to be vaccinated. So how to read it? So I think because of the human right as well, because of the reasons why is because of the human right as well. Okay, regarding the Malaysian scenario, and I believe that all countries in the world are having the same scenario. Okay, we started COVID-19 early March, even though it happened earlier in 2019, I believe. But somehow, the first MCO, the first implementation of legal measure taken after March 2020. Okay, in Malaysia, the legal public health response, we do have two main mechanisms. The first one is legislative, and the second one is the executive mechanism. So legislative is very important. Everything we need is law. So everyone, if we want to enforce everything, we need law. So in Malaysia, we do have one particular very important act known as Prevention and Control of Infectious Disease Act 1988, known as PCIDA. So based on this single and specific act, it has granted a power to others in order to implement or to invoke the MCO, the Movement Control Order. And I believe that we have a few series of MCO. Like in Malaysia, in 2020, we have 1, 2, 3 kind of MCO. And starting from the MCO, we have another kind of EMCO, RMCO, a few type of MCO. So the Ministry of Health also given the power to proclaim any area within Malaysia as an infected local area. So any infected local area based on the locality in any state in Malaysia. So this PCIDA has given a power to the authorized officer to direct any person to be isolated, to observe, to have a treatment, to surveillance, and to take any other kind of measure as the authorized officer consider as necessary to control the disease. So meaning that based on this one particular act, it gives a power to the officer to take a legal measure, and the power given to them especially been authorized by that specific act. Okay, based on that particular PCIDA as well, and I believe that all countries in the world having this kind of progressively stringent measure like a suspension of international travel in and out. You cannot go abroad, and the other people abroad also cannot in, and drastic reduction business hour. This consider the economical aspect, not only Malaysia and also all countries in the world. Closure of public park, you cannot go to the shopping mall, restriction of public and transportation service. So this is the mechanisms of why they are implementing the MCO. Banning of interstate, not only the international abroad, beyond, but somehow the interstate level, traveling from one state to another state also be restricted. And the most stringent restriction is limiting all daily activities to within a 10 kilometer. So 10 kilometer, you just imagine how far the 10 kilometer is. So if you go more than that, of course, you will be punished. That is the implementation of MCO that time. Okay, as I mentioned to you just now, we have a series of MCO, Movement Control Order 1, 2, 3, and based on the kind of high rates of infection, so MCO, also known as Enhanced Movement Control Order. So for a certain locality, with when the statistic or the number increase, so they call the place or the locality as an Enhanced Movement Control Order. So the people in that particular place need to be restricted. Okay, for example, in Malaysia, we do have like in that particular year, for example, like in Kedah, we have a green color. So green color meaning that very safe because of the statistic is quite low. But for example, like in Kelantan, in my hometown, which is that time, it was a red color. So red color meaning that the statistic is quite high. So the people in Kedah cannot cross to go back home in Kelantan because of the red color. So the violation of the MCO, because this is what has been mandated according to the PCIDA just now, so you can be summoned and like 1,000. I don't know how to convert it to Indonesian, so but USD is around 240 that particular year. So because of that as well, in order to make sure the measurement, the public health measurement according to the law to be successful, Malaysian Army together with the RMP, the Royal Malaysian Police, in collaboration together in order to make sure that people, especially the Malaysian citizens, are following all the restrictions and rules and regulations that has been granted by the PCIDA just now. So this is a very small size, but somehow this is the way how Malaysian government advertise all the information, and this one is in Bahasa Melayu. With regard to the response, of the immediate healthcare preparation for the COVID-19 pandemic, of course, at that time when it first occurred, it first happened, of course, we have insufficient place in order to locate people who have been infected. And the numbers of statistics proven increase from 1 day to days. So it needs like an effort between public and private hospital to accommodate the growing number of cases and infection. So these are the collaborations, not only one ministry or agency involving the government, the public, but as well as a private sector as well. And these are considered as a normal or legal measure that has been taken at that time, like a contact tracing. We need to do a contact tracing. We need to trace the people that have been infected. So these are the considered the requirement for those who have been traced to be infected to be quarantined 14 days that time. Like nowadays, this year, if you have been infected, it only minimize into I think 6 days or 5 days to be quarantined. Previously, it's supposed to be 14 days. Screening process, and this one is very important, especially for those who want to coming in and coming out. So this is the process that in order to prevent the spreadness of the COVID-19. Okay, healthcare response to the community transmission to COVID in Malaysia. So this is a comment because any new cases that has been detected, so something has been taken into consideration. Even though it happened in 2020, but now it's 2020. Even though we consider it decreased in the number, but it still happened. So it still happened. So we cannot ignore all the SOP and all the process that has been taken earlier in the beginning of 2020. even though it seems like, oh, we have just followed the SOP. No, but somehow you have to consider that the COVID-19 is still happening until today. As a conclusion from the last first mechanism just now, so these are the way. These are the stringent control measure that has been taken by Malaysia in order to make sure the public health citizen in Malaysia to be taken into consideration. Okay, the second one, the first one is legislative regarding the law, and the second one is executive, the one who can execute all the legislative mechanisms just now. So in Malaysia, we do have a National Security Council. So anything which involves a disaster, and you have to remember, pandemic, starting from endemic to pandemic, later on it will become a disaster, and National Security Council take place in order to coordinate. So anything happen in collaboration with the Ministry of Health, in collaboration with NADMA, in collaboration with all agencies in Malaysia. Okay, as a conclusion, as I briefly mentioned to everyone just now regarding the movement control order, starting from considered a draconian restriction at the first time, and then it becomes as a conditional movement order because we have a condition. You still can move, but under conditions, and later on, after that, still in 2020, recovery movement. So this one is considered less restriction. So meaning that you can move far. Before, you can only move within 10 kilometers, and then you can move across the interstate. And in 2020, you can go abroad. I can go to Indonesia as well. I was in Spain last June. So meaning that now in year 2022, we can go everywhere we want to go as long as we follow all the procedure. And the most important thing, as I mentioned to you just now, with regard to the law, just now PCIDA. So these are the punishment. The punishment for those who in violation of the SOP that has been implemented to us, especially the citizen in Malaysia. First category, what happened if you violated the SOP, so you'll be punished for 5,000. The second category, maybe the less, 3,000, and the third category maybe lesser, 1,500. So these are the offenses with regard to the COVID outbreak. So we have to follow that one. I never been punished for this kind because I am the one who follow the SOP. So, but of course, human beings is always, they are not trained to not to obey the law, but sometimes in some situation we try not to obey the law. So these are the punishment for those who are in violation of that kind of a law. So now it's 2020.
1 minute. Excuse me, doctor, 1 minute.
Oh, 1 minute. Okay,
Yeah.
I try to conclude. Okay, now it's already 2020. As I mentioned to you just now, even though the number is decreased, but COVID-19 is still happening. So these are, actually there are many guidelines in 2020. It depends on locality, it depends on, for example, like the private sector, the public sector, the guideline of infection, management of healthcare, and everything. So we do have a current legal health response towards everything. So for that particular action, they have to follow all these guidelines. But you just remember, guideline is something that need to be followed, even though there is no punishment, but we have to follow all the guidelines. So the others, the poster or how government advertise or give information, dissemination of information to us as the public in Malaysia, starting from the year it happened, after that in government agency, and now we are in the phase 4. So until today, we have to follow all the kind of rules and regulation that has been implemented to us. So I believe that's all on my part. And thank you very much for having listened to my speech today. Thank you.
Thank you, Dr. Nur Anita Abdullah. Ladies and gentlemen, the most important thing from the Dr. Nur Anita's presentation is that there are two responses regarding Malaysian health response towards COVID-19 outbreak. Those are in the level of legislative and executive.
Executive.
Yes, the executive mechanism is National Security Council, NSC. And the former one, the legislative mechanism, is the Prevention and Control of Infectious Diseases Act 1988, Act 342, PCIDA, which the government invoked to proclaim a series of MCOs. Ladies and gentlemen, let's move to Professor Olivier Faure. He will deliver his presentation on executive powers in managing the COVID-19 pandemic in South Africa, reform proposals to strengthen parliamentary oversight. Professor?
Yes, Chair.
Are you ready, Professor?
I am ready.
Okay, time and the screen is yours. Please, Professor.
Good afternoon, ladies and gentlemen. Thanks very much for giving me the opportunity to present a paper, organizers of the conference, and thanks very much for our very strict chair. I know that I'll be cut off after 15 minutes, so I have to be brief and straight to business. I was approached to present a paper in the conference, and because I had to juggle many balls, I managed to put together a draft. It's just a draft, and the thoughts will develop as I present and also as I get time to revise the paper. As you can see from the title of my presentation, I'll be talking about the use of executive powers in managing the COVID-19 pandemic in South Africa, and then indicating provisions in our law that need to be amended in order to enhance oversight by Parliament, to enhance oversight and accountability on the part of the executive by the national government. In order for me to be able to achieve the objective of my presentation, I've structured it into 5 parts. I begin by giving you a brief context, which is largely aligned, even the presentation itself is aligned to what Anita has already done. Thereafter, I tell you about the legislation which we have in place to manage pandemics like COVID-19, and then I'll briefly summarize the responses that were adopted by the government of South Africa to the pandemic, and then indicate the area where some have already called for reform in terms of our law. And then I'll end with a few conclusion words. So we know it is common knowledge that on the 11th of March 2020, the World Health Organization declared COVID-19 he called on governments across the world to take urgent and aggressive action in order to curb the spread of infections and deaths. And he urged countries to be able to detect, test, treat, isolate, trace, and mobilize their populations in response to the pandemic, and to also ensure that civil society as a whole was involved in the response of government. Importantly, governments were urged to strike a fine balance between protecting health, minimizing economic and social disruption, and respecting human rights. As you'll see, and I think it's something which also played out in many countries, this was the most difficult aspect of a lot of measures that governments had to implement. How to strike a balance between protecting livelihoods and protecting lives, while ensuring that there was minimal disruption to socioeconomic activities. Before I move to the legal framework that underpins the management of disasters in South Africa, let me draw your attention to the fact that in terms of the Constitution of South Africa, the country can be described as a semi-federal state. A semi-federal state which is made up of 3 spheres of government. We have the local sphere of government, which is made up of 257 municipalities that exercise executive and legislative powers that are vested in municipal councils, which can be delegated to executive mayors to run the affairs of the municipality on a day-to-day basis. So in the context of local government, the doctrine of separation of powers is blurred in its application. And then in terms of the, you can call it second level or sphere of government, we have provinces, 9 of them in total, which are headed by premiers and provincial executives that are referred to as MECs, members of the Executive Council of provinces. And each province also has its own parliament, so we have provincial legislatures. And then at the national level, we have the president and members of the members of the executive branch of government, that is cabinet ministers leading the state. And then we also have the National Assembly and the National Council of Provinces that make laws that are generally applicable across the board, across the country. And then our constitution also gives an indication as to the areas of competencies of the different spheres of government. And disaster management, in terms of Schedule 4A of the constitution, is an area of competence of national and provincial government, which simply means that national and provincial governments can make laws and implement them in order to be able to manage a disaster. And even though the areas of competence in the constitution suggest that municipalities are not directly responsible in the management of disasters, but when you look at the legislation which deals with this, you will come to realize that they are expected to be able to play a role. And some of the services that are provided by municipalities, such as water, electricity, firefighting services, health, and even social housing, are services that can be impacted negatively when there is a disaster. So in terms of the Disaster Management Act, which is the legislation dealing with the management of disasters in the country, each municipality is supposed to have a disaster management plan. The same applies to provincial governments and national government. And every municipality is required to have a disaster management center, which actually coordinates disasters when they occur. If it's a local disaster, then it coordinates the activities that are going to take place within the municipality, within the jurisdiction of the municipality, and support is then cascaded from national and provincial government downward. If it's a national disaster, that is also used to ensure that services are provided to those that are affected. And then in terms of our legislation, when there's a disaster, the president is supposed to, when there's a national disaster, the president is supposed to establish an intergovernmental committee, which is made up of ministers and premiers and MECs of provinces, and also representatives from municipalities to be able to make decisions in relation to how the disaster should be managed. And that committee is supposed to be chaired by the Minister of Cooperative Governance, basically the Minister of Local Government. And in terms of our constitution, the president also has powers to appoint any other structures that may be necessary to help with the management of the disaster. In context of COVID, the president appointed a coronavirus command council, which was made up of experts in the field of epidemiology to provide advice on how to manage the situation. But the most interesting provision which I want to draw your attention to is Section 27 of the Disaster Management Act. If you read that provision, I don't have time to read it because of the limited time that we have, you'll see that the Minister of Local Government has a lot of powers, and when the president declares a state of national disaster, basically the minister then uses this provision to be able to declare a national disaster if existing legislation is inadequate in dealing with the matter, or if the minister deems it necessary. And once that is done, the minister is able to make laws, we call them secondary legislation, through regulations. So the minister, in consultation with other ministers, come up with a lot of regulations, like in the context of COVID, in relation to all the matters that are listed in subsection 2. So you basically have a situation where the minister can make law in relation to any aspect that concerns an ongoing disaster. And once a minister declares a national state of disaster, that is supposed to last for a period of 3 months, and the minister has powers to be able to call it off if the problem is addressed before the expiry of 3 months, or if that is not addressed, if the minister deems it necessary, the minister can be able to extend a state of disaster for another month. And that can carry on continuously as the minister deems it necessary. In the context of the COVID-19 pandemic, that played out for a period of more than two years. And it is interesting to note that this legislation does not provide any checks and balances to the powers that are vested on the minister in terms of Section 27 of the Disaster Management Act. So the minister has very, very wide discretion, and as we'll come to see, some of the powers that were exercised by the minister in terms of this legislation were frequently challenged in court, and at times the court ruled against the government, and that's something which we can discuss in the context of the discussion which will follow the end of our presentation. So in order to curb the spread of the virus, after announcing a state of national disaster in March 2020, the president imposed a very hard lockdown that lasted for 11 weeks. And during that period, we were only allowed to go out to buy food. And essential services, some of them could be provided, especially health services, but shops were closed. And even we always talk about babies who were born during that period, whose parents were unable to even go to shops to be able to buy clothes for them, even though it was also very cold, it was winter during that period. And in fact, a lot of the regulations that were adopted at that time were not really rational, because we were also experimenting and were not aware of what we were dealing with. And after a lot of criticism from civil society and the public, the president decided to come up with a risk adjustment level to the management of the disaster, almost in line with what Anita presented on. So we had about 5 different levels that the president put in place, which was used to manage disasters, manage the COVID-19 pandemic. So the most stringent one was alert level 5. During that level, only basic services were provided. And these levels were calibrated, taking into consideration the spread and impact of the pandemic and the preparedness of our hospitals to be able to cope with the number of patients that turned up requiring medical assistance. And then level 4 also was very stringent. There was a bit of relaxation in relation to physical exercise. Basically, we could go out for about 2 hours a day in the morning between 6 and 8 o'clock to exercise a bit, and after that, everybody was home. And a lot of people raised questions as to the rationale why we were able to go exercise in the morning and not in the afternoon or in the evening. And a lot of things were banned, no interprovincial movement. Funerals took place without family members being present. And then things like cigarettes were not sold. There was a complete ban on the sale of cigarette and alcohol. For those of you from Islamic countries, it's not a big problem, but with us here in South Africa, it was really a big problem. People severely criticized the government that they were unable to buy alcohol and drink despite their confinement at home. So under level 3, the conditions were also very, very stringent. Very limited activities were allowed, mostly essential services also. And then we had a prohibition of a lot of socio-economic and cultural gatherings, even religious gatherings were prohibited, and movement between provinces and even international travel was also restricted. And then on level 2, things were a bit relaxed. I was able to visit Tanzania in 2021 when we were under level 2, and because the situation was very fluid and constantly changing, some of us were worried each time we traveled out of the country that we may be locked out of the country when we attempted to re-enter. So we also had level 1, which is what we had a few months ago, which basically required us to adhere to very basic guidelines: washing of hands, sanitizing, maintaining social distance, wearing of masks, and that mostly took place when the spread of the virus was contained, and when government did not deem it necessary to be very strict on the population. And you will come to realize that if you read some of the publications that have come out already assessing the impact of the COVID-19 regulations, that the impact was very severe in terms of the economy, in terms of livelihoods. We know that in the informal sector, about 1 million jobs were lost only in 2020. In the formal sector, also a lot of jobs were shed because the economy had to shut the contract since a lot of economic activity could not take place. We even got to the situation where the government was able to introduce a basic income grant of about 350 rand, provided to everybody in South Africa between the ages of 19 and 59 who could not benefit from the welfare measures that are already in place. And civil society organizations had to go to court to challenge the government to extend that to foreigners that live here temporarily, and that was given. And the government had to amend legislation after that to ensure that when there is a disaster in the country, assistance is provided to anyone who is affected and who needs help, and that assistance is not only provided to citizens. So following a lot of criticism, a member of the opposition party, a member of parliament, decided to introduce a private bill in parliament to amend the powers of the minister under section 27 of the Disaster Management Act. And he proposed that the powers of the minister to declare a disaster, a national state of disaster, should be limited to at most 21 days, and that after the minister declares a state of disaster, for the minister to be able to renew the state of a disaster, the minister should require parliamentary approval. And if it's a provincial disaster or a local disaster, approval should be sought from provincial legislatures or from municipal councils. And he also proposed that we should look at the threshold which is required for the various legislatures to be able to extend such a disaster. And this was debated in Parliament and eventually vetoed by the ruling African National Congress. They were not prepared to see the powers of the minister scrapped. Luckily, in June this year, the president lifted all the COVID-19 restrictions. We are simply required to adhere to level 1 guidelines, which is basically social distancing, sanitizing, wearing of face masks if we deem it necessary. And some of us are excited that we are returning to contact teaching in universities because the restrictions have been lifted. But when we look back at what happened and a lot of the criticisms that were leveled against the government, I think that some of the proposals that were put forward by the Freedom Front Plus, the Member of Parliament in his private bill to amend the Disaster Management Act, are tenable. We can support some of them. I think that personally, the minister should not have very, very wide powers that cannot be controlled by even Parliament in managing a disaster. We know that it was something which was unprecedented. It was the first time to happen, and systems had not been put in place for virtual meetings of Parliament to be able to take place. But now we have systems in place, and in future, if we have such a situation, I think that Parliament should be enabled to be able to hold the executive to account and to also play an active oversight role in monitoring a lot of the regulations that are adopted by ministers, and where necessary, to be able to repeal some of them. That's a brief summary of the reform proposals that I've outlined in part 4 of my presentation. We can talk about the details in the context of the discussions that will come at the end of our presentations. I end by concluding that there was good rationale to the private bill that was introduced by the Freedom Front Plus. There are things that we can learn from there to improve our legal framework for disaster management in the country, should we be unfortunate to have another pandemic as severe as COVID, and that it is unfortunate that none of the proposals that were put forward were actually incorporated in legislation, because the government, the ruling government, used its overwhelming majority to block the reform proposals. That said, I think that I can end my presentation there, and thanks for listening. I look forward to the engagement at the engagements at the end of our presentations, and I'll be able to take questions and comments then. Thank you very much.
Thank you, Professor Lefifo. Thank you for applause of participants here. And I just want to repeat the conclusion. The private member bill was hindered by the National Assembly as the ruling African National Congress, ANC, voted against it in 2022 this year. And therefore it gives the Minister of COGTA, the Minister of Cooperative Governance and Traditional Affairs, if I'm not mistaken, Dr. Eko Sazana Clarice Damini Zuma, right, Professor?
Yeah,
okay.
You're correct.
Yeah. Give him a free rein to make decision about any future state of disaster. Ladies and gentlemen, at this moment, I'd like to invite you all participants, both in this hall or in the Zoom, to deliver your questions. At the beginning, let's take in 3 questions first. So please mention your name, the question for specific speaker, and the question, and please make it shortened. Yeah? 1, 2, 1 more? Okay, 2 first. Yes, please. Okay. In the midst of the hall, please.
Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, moderator, and all the distinguished participants. My question will be addressed to the Dr. Juli, since I found the interesting topic on your last slide presentation. It related to the reluctance of the Indonesian government to comply with the international human rights law. Why the Indonesian government still reluctant to comply with the common standards of human rights that govern in the UDHR and prefer to maintain or uphold the Asian or local value? Does it base on the presumption that the UDHR was more Western-centric and cannot accommodate our value? Thank you.
The next. Okay, next question. Yes, please.
Jack. Assalamualaikum warahmatullahi wabarakatuh. Thank you for your opportunity to ask. I would like to ask to Dr. Juli regarding how your response about the rise of digital authoritarianism in Indonesia. We know that the several cases such be the activists into the social media has been jailed or has been suspect into the criticize of the government policy, and what should the government have a regulation or a policy which the points of human rights itself. Thank you.
Okay, Doctor, would you please to directly answer them? Yes, please.
He didn't mention the name, so I just answer the question. Thank you so much for giving me a very important question. Yeah, the first question is about the reason behind the reluctance of the lawmakers to comply with the international human rights standard, and you raise one of the of the reason that usually rise is that Universal Declaration of Human Rights is not compatible with the Indonesian values, for example. Yes, until today there is like pro and con. In ASEAN countries particularly, they propose the Asian values, saying that not all human rights values stated in the Universal Declaration of Human Rights is suitable with the ASEAN culture, but actually, if we can look at who is actually proposed the Asian values was the Minister of Singapore, I think, and then follows by Suharto and others, leaders in ASEAN countries. because they think that economic and social and cultural right is more important than civil and political rights. So we want to focus to with the program of development, and by that reason, sometimes the government ignore the civil and political rights. So that's why there is a lot of cases during the new order era. For example, people are get arrested because they protest to the government, or sometimes we also found that many cases is not follow the rule of law in the court. For example, the law enforcement ignore the equality before the law or the presumption of innocence, etc., etc. So what I want to say that if we look deeply to the Universal Declaration of Human Rights, actually they have a balance between civil and political rights and economical, social, and cultural rights. Because we also accommodate, the need to protect economical, social, and cultural rights. But we need to understand that civil and political rights is more individual rights, the rights that belong to everyone, because we are, as a part of human dignity. The human right that is not given by state. Therefore, the state must be careful when try to apply the law to restrict the human rights of the citizens. And of course, if we want to develop economical, social, and cultural rights, this is also possible actually, because Universal Declaration of Human Rights is also give the room for the country to focus on economical, social, and cultural rights. But we need to remember that both right is interrelated and interdependency. So we cannot just focus on ECOSOC, but we forget civil and political rights, or the other way around. So we need both, and therefore I think. When the people say that, Universal Declaration of Human Rights is not compatible with our values, I think it just, according to me, is kind of justification to offer limit the citizen right, to ignore the citizen right, to violate the citizen right. This is what I observe. And the second reason is that when we look at the historical context, how the Universal Declaration of Human Rights was formatted, was drafted, actually those discussion was accommodate all the needs of the countries in all over the world, not only Western countries, but also the countries who were living in the Middle East, the countries who are living in the Southeast Asia or Africa. So actually, what we can see in the Universal Declaration of Human Rights is common standard. The minimum standard, how we can protect the human right of the people. The minimum standard, meaning that we cannot lower towards that standard. But if you want to make higher compared to that standard, that will be good. But to make it lower, it's something that we cannot accept actually. So when we look at deeply in the Universal Declaration of Human Rights, for example, when we talk about freedom of torture, none of the citizens in the world agree that the state should, torture their citizen. That's the common standard. no matter where we are coming from, either we are coming from Western countries or we are coming from Southeast Asia countries, for example. We don't want our state apparatus torture us because we are human beings. Another example is, for example, everyone has the right to choose their belief and, embrace their belief. That's a common standard. No matter you are coming from Southeast Asia or Western countries, you agree with that common standard, right? Another example, the right to be free from slavery, for example. No one wants to be a target of slavery, no matter where you are coming from. So maybe my question is, which one part of Universal Declaration of Human Rights that not compatible with our values, our Asian values? That's my question back to that question. You know what I mean? So, and then another reason is that as a part of the United Member, we have the commitment to respect human rights of the people. Because when we talk about human rights, actually, we want to limit the authority of the state, right? And this is something that, very often the authority or the power doesn't like it.
1 minute, sir.
Yes, yeah. So that's the point of my answer for the first question. And the second question is about digital authoritarianism in Indonesia, suspect to criticize the policy. Oh, okay. So in my opinion, yes, that freedom of expression is not an absolute right. I agree with that. But to limit the freedom and expression should be very careful. The limitations should be very strict, meaning that if this is really needed for the state to limit your freedom of expression, then the state can do that. So the first is the limitations should be strict, not easy to limit. And the second is when we talk of freedom of expression, we cannot, limit the citizen freedom of expression for, the purpose of discriminated certain people of group or certain religion or certain community. No, because the reason must be necessary why the state need to limit the freedom of expression of the people. And when we talk about defamation law in Indonesia, we call it pasal-pasal pencemaran nama baik, ya. Of course, we need to protect the right of others, But actually, when we want to respect the right of others, because of fitnah or the news that actually is fake, for example, then it's become the private matter, not criminal matter. So we cannot, we cannot bring the private matter to the criminal matter. If you are the target of fitnah, then the people who are being fitnah should be sued in the court into the private matter, not to bring this issue to the criminal aspect. Because when you bring this matter to the criminal aspect, then you allow the country, to interfere your relation between one and another, right? So when this happens, then those articles, very often to be used by the authority to keep your mouth shut. Because the authority who have the power can utilize those articles to make you fear to criticize the government. That's my opinion about that question. Thank you so much.
It's beautiful. Ladies and gentlemen, it's really not easy to answer the government's reluctant and the lack of appreciation of the essentials of human rights. Although the state Indonesia ratified almost all international human rights law instruments, but the Rome Statute of the International Criminal Court of the 1998. However, Dr. Chekli eloquently argues that the political interests have dominated the government's public arguments of developmentalism, right, instead of appreciating human rights. And still, it has happened, and it has remained to be seen. Ladies and gentlemen, I'd like to invite Dr. Professor Nur Anita Abdullah and Professor Olivia Fo to give such an intellectual reflection based on their primary arguments at their presentation. The first is for Professor Nur Anita Abdullah, please.
Thank you very much, Chairperson, just now. Actually, I don't know how to conclude as an intellectual reflection, but I can summarize a little bit within 1 minute based on my presentation just now. As well as I can summarize or conclude that a public health measure cannot be implemented alone. That's all. It's very simple. Because when we say it is a legal response, it needs to be implemented by everyone. Even though the government who implement it, but of course we need everyone to respect it and of course try to implement it. So then it will be successful, because we know that based on this kind of outbreak, we don't know when it will stop. So what we can do, prevention is better than cure. So we try to prevent, but at least we can get the cure at the end of the day. So that will be the result. I think that's all for me. Thank you.
Thank you very much, Professor Nur Anita Abdullah. Terima kasih. And then let's move to Professor Olivia Fo. Please, Prof.
Thanks very much, Chair, for giving me a minute to say a word in relation to the presentation I did. I think that the calls for us to be able to amend Section 27 of the Disaster Management Act should be understood within the context of the constitution that we have. If you look at the preamble of the Constitution of South Africa, it tells you that we are committed to moving away from the history of the past and to establishing a society that is based on certain values. You will see there is emphasis on the rule of law, you will see there is emphasis on accountability, and this is an area which has been well traversed by constitutional law scholars in the country. It is common to hear about people talk of the notion of transformative constitutionalism. And in essence, the emphasis is on the fact that the exercise of every public power should be subject to stringent justification in line with the values in the Constitution. So we cannot continue to have a situation in future where the minister exercises such vast power without any form of parliamentary control. It is a bit more strenuous to require that such control should only take place through judicial review, and at times access to court can also be hindered by a number of factors, including cost. So it is against this backdrop that I think I should be able to flesh out or further develop my paper and make a stronger case based on existing scholarship on the issues that I've raised as to why that provision of the Disaster Management Act ought to be amended. Thank you.
Thank you very much, Professor Fo. Thank you very much, Professor Nur Anita Abdullah. And thank you very much for Dr. Chekli Pratiwi and moderator and you all. And I'd like to pass you this moment. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you so much, Pak Hasnan, Bu Chekli, and also Professor Oliver and Dr. Nur for the fruitful presentations. I know maybe some of you are already hungry, ready for the dinner time, Bapak Ibu. Ladies and gentlemen, And for our dinner time is not here, so you will enjoy pool view downstairs. So if you have any belongings now, please bring your stuff with you because you're going to close this room, and please enjoy the dinner, but we are going to be back at 7, Bapak Ibu, to have our second plenary sessions. Still with our beloved moderator, Pak Hasnan ya. Jadi Bapak Ibu silahkan, ready, dinnernya ada di lantai 1, dekat kolam renang. Monggo yang mau renang juga boleh sekalian ya. Ketemu lagi kita jam 7 nanti ya. Mohon untuk datang on time seperti sebelumnya. Terima kasih banyak dan sampai ketemu nanti pukul 7. Oh, yang di Zoom juga, thank you so much. Don't forget to join back again at 7 ya. Make sure you join back again at 7. Still with Pak Hasnan ya. You may have your Maghrib prayer, dinner also, but in your house definitely. See you back again at 7, everyone.
Host representatives of the Republic of Indonesia, especially when dealing with the discussion of the draft of law on the renewable energy in Indonesia. Her roles are significant for the state. She has contributed to several levels of the state institutions, from regional to national. Her academic publications are outstanding. Her current works are a reconstruction of consumer protection in the banking sectors, making the legal perfection of the substantive justice. And then the reconstruction of the settlement of banking dispute, 2019, and the construction of the taking of agreement of the House of Ownership, the perspective of the legal certainty, 2020, and the last but not least, the business competition, cartelization, and the cases of law in Indonesia, 2021. And our second speaker will be Dr. Fernando Arletas. He's a professor of international relations at the Zaragoza Defense University Center. He obtained his Bachelor of Laws, Master of Laws, and doctoral degree in legal sociology and political institutions from the University of Zaragoza. He was a postdoctoral researcher at the Centre d'études de recherche internationale communautaire, l'Université de Marseille. In addition, he has extraordinary scholarly experience in various institutions in the world, such as the CONICET, Argentine Research Council, Universidad de Buenos Aires, then Universidad Externado de Colombia, and then Universidad Nacional Autónoma de Mexico, and then École Normale Supérieure de Gazon, Universidad Católica Argentina, and Université Claude Bernard, Lyon. He has specialization in international human rights law, relations between law, state, and religion, and international migration. He has also various academic works, such as prevention and repair of environmental damage, theoretical problems in Argentine perspective, 2022. Nature and scope of asylum in the inter-American human rights system, 2016, and state neutrality and the legal status of religious groups in the European Court of Human Rights case law, 2016, and restriction on, ladies and gentlemen, the speaker at this opportunity will be given to Dr. Fernando Arletas, and he will deliver his presentation on restrictions on human rights in time of epidemics. Dr. Fernando, are you ready? Yes, the time and screen
Hello.
are yours.
Can you
Please.
hear me? Can you hear me? Is
Yes,
everything
great.
okay?
Yes,
Yes,
very
okay.
good. Yeah.
So, well, first of all, thank you very much for the invitation. Thanks to the university. I am very pleased to be here with you. And I would like to apologize because of the time difference. I'm now in Spain. I couldn't attend the opening ceremony. I'm sure it was great. So thanks again, and I will start with my subject, which is, as you have said, restrictions of human rights in times of epidemics. But first of all, some preliminary remarks. I will talk about restrictions to human rights, and I will for this I will approach the subject and an international law perspective. I work on international law, international relations, so this is my point of view. For this, I will rely mostly on the international law of human rights. And as you may know, the international law of human rights is mostly conventional. That is made up of international treaties. And international treaties, of course, are binding only on those states that have ratified those treaties, that have ratified those conventions. And Indonesia hasn't ratified many of these conventions. So some international standards from this convention are in principle not applicable on Indonesia. However, some of these standards, and I would say even many of these standards, are also customary law. That is part of customary international law, which is binding in principle at least on all states. That is, customary international law is binding on all states, even on those states that have not ratified specific convention. So I will speak in general about all of this. I cannot analyze in each case if we are in front of a rule, an international rule, which is only a conventional rule, or if we are in front of an international rule, which is also a customary rule. But if you have time after the presentation, if you have time for some debate, of course we can delve into this issue too. So I will speak about international human rights standards and measures related to the protection of public health, and in particular the protection of public health in times of epidemics. First of all, we have to know that when tackling public health issues, ordinary public health issues or epidemics, exceptional public health issues, states adopt different measures that can restrict human rights. We have seen these during the COVID emergency, the COVID time. We have seen that states have adopted measures like restrictions on free movement. You cannot go there. You cannot go there. You have to stay home, etc. Restrictions on other liberties, like the liberty of assembly, and even in some cases some harder measures like compulsory vaccination or compulsory medical tests on people. So all these measures are all the measures that have been adopted by states during the time of the COVID epidemic, restrict in some way human rights. These are measures that restrict liberty of movement, that restrict privacy, that restrict liberty of freedom of assembly, and in some cases even freedom of religion, and even in some cases physical integrity. For example, if compulsory vaccination measures are interference with the physical integrity. So the big question is, to what extent these measures, these kind of measures, are legitimate under international standards, are the international human rights standards. To what extent are these measures legitimate? So to analyze this issue, this problem, I will distinguish between two kinds of measures that are two kinds of restrictions on human rights. The first are normal limitations on human rights. That is, a limitation that states can establish on human rights under normal situation, under normal conditions. And this is everyday life. This is everyday regulation of human rights. For example, you have the right to move freely. You have right to free movement under international standards. You can move freely from one part of your country to another part of your country. But states can, for example, rule or regulate how cars must go in cities and outside cities and all that. That's normal regulation of your liberty of movement. Okay, and I think another usual example for them, I have a right to the protection of my private property under international standards, but states can establish taxes, and I have to pay taxes. That's a normal restriction, normal limitation of my right to private property. But besides normal limitations, there are also exceptional limitations, exceptional derogations on human rights standards, and this kind of restrictions are stronger limitations, stronger restrictions on human rights, which can be used under emergency situations, in emergency circumstances like the COVID epidemic that we have lead, or a war, or some public order issue, or something like that. So exceptional derogations, exceptional limitations can be used in emergency circumstances. So what are the conditions for these two kinds of restrictions to be legitimate? Well, concerning normal limitations, concerning usual, normal, everyday limitations, it is quite usual to say that to be legitimate, limitation of human rights must be first established by law. Only general laws can establish limitations to human rights. The limitation of the human right must have a legitimate aim, and the limitation itself must be proportionate to this aim. And well, concerning limitations for public health reasons, and concerning particular limitations during epidemics, we have to say first of all that public health is in itself legitimate aim. So you can restrict human rights. That's the general principle. You can restrict human rights to protect a legitimate aim, or under a legitimate aim. For example, to protect public order, or to protect public morals, or for example, to protect public health. You can restrict human rights to protect public health. But these restrictions must be established by law and must be proportionate to the aim of protecting public health. We'll come back to this issue in some minutes. For exceptional derogations, conditions are stronger. Conditions are harder, because exceptional derogations are themselves harder than normal limitations. So to apply to legitimately exceptional derogations, you have to be first of all under an exceptional situation, an emergency situation, and second, derogation must be temporary. You cannot apply indefinitely these kinds of exceptional derogations, and of course, as normal limitations, exceptional derogation must be necessary and proportionate to the aim you are targeting to the aim, which is usually the aim of combating, fighting the public emergency. And in both cases, in both the case of normal limitation and in the case of exceptional derogations, limitations cannot be discriminatory. You cannot discriminate legitimately against a group of people when applying these measures, either normal limitations or exceptional derogations. And here we have some questions, particularly related to public emergencies and public health emergencies like COVID-19. And there are many questions in relation to the prohibition of discrimination. I will talk only about two of them before entering some particular measures. The first question is if legal distinctions established on the basis of health status are discriminatory. That is, can the law forbid some people from entering a part of the country, or from attending some public meetings, or from working in some places because of the health status of that people? For example, can the law forbid me from entering an airport if I am COVID-19 positive, for example? Well, there is not a clear answer for these, but in general, and we have some examples in international case law, international human rights case law, and the general answer is that these restrictions are not discriminatory if they are necessary and proportionate to the aim of fighting that disease or that public health emergency. For example, you can't legitimately forbid people who are COVID-19 positive from entering an airport, but a similar prohibition on people who are HIV positive from entering an airport would be legitimately, because this kind of prohibition would not serve any proportionate aim or for in the fight of this would not be a proportionate measure in the fight of HIV, because of the way in which HIV propagates. And the second question is about the effects of some measures on some particular group of people, particular groups of people. We know that restrictions as those applied during the COVID crisis may have a particular effect on a particular group of people. For example, I am a professor. I can when I was forbidden from going outside my home because of the COVID-19 crisis, I could continue working at home, online and that. But for other group of people, this was not possible because of the kind of work of those people. So it is clear that measures can affect more heavily some group of people than other groups of people. So in this case, the general principle would be that states can adopt those measures even if they have a disproportionate effect on a particular group of people, but states have also have to apply also compensatory measures in favor of those particularly affected groups of people. Well, after this, the general consideration of the legitimacy of the measures, I will analyze some particular measures. I know I'm running out of time, so I will analyze some particular measures adopted under the COVID emergency or during the COVID emergency. So first of all, maybe we all know one of the first measures adopted during that time was isolation of COVID-19 positive people, or quarantine of suspected cases, even the prohibition to go out during some hours, curfew, or prohibition to go out in general. So this was different in different countries, but in general, all countries have adopted some kind of measures like this. Are these measures, or were these measures legitimate? Well, the general opinion, I would say, it's difficult to synthesize this in some minutes, but the general opinion would be that yes, these measures are legitimate, but these measures are legitimate only to the extent that they are proportionate to fighting the epidemic. So for example, they cannot last. They cannot last beyond what is strictly necessary to fight the epidemic. Are border closure measures and restriction of movement inside the country legitimate? Yes, but only under the same considerations. And I'm going to finish because I know I have only 1 minute. Only under the same considerations, they are legitimate if they are proportionate to the aim of combating the epidemic. And finally, the most difficult kind of measure, which is compulsory medical checks and compulsory medical treatment, like vaccination. Is compulsory vaccination legitimate under human rights standards? Well, once again, there is no clear answer, but we can suspect that compulsory vaccination can be legitimate as long as vaccination has not heavy side effects. There is a very interesting case under consideration by the European Court of Human Rights on this issue at the moment. So to conclude, just to say that epidemics and health emergencies in general usually put societies under heavy stress, and governments adopt different kinds of measures during these times, measures that affect human rights and which must be considered under the point of view of human rights standards to analyze their legitimacy. So that's all. Thank you very much for your attention. I will be happy to discuss the issue with you if we have some time for debate later. Thank you.
Okay, thank you, Doctor. Ladies and gentlemen, the court's case law on human rights during the health crisis is still developing, with a large number of received and pending applications before it, and the continued evolving the nature of the pandemic. It's forecast to continue expanding for many years to come. You know what? Actually, the Dr. Fernando argument. It has remained to be seen, it's open to be debated. Okay, well, we will invite the second speaker here, Dr. Herawastuti, sorry. And the specific topic that she will deliver is the legal strengthening in dealing with the digital financial development. Yeah, please, Doctor.
Assalamualaikum warahmatullahi wabarakatuh. Bapak Ibu yang berbahagia, peserta INCLAR, malam ini saya yang terakhir dan mohon berkenannya nanti saya memaparkan dalam bahasa Indonesia. Jadi mohon berkenannya saya tidak menggunakan bahasa Inggris ya, karena Ya, khawatirnya nanti Bapak Ibu malah ndak paham apa yang saya sampaikan. Jadi mohon berkenannya materi ini saya sampaikan dengan bahasa Indonesia. Yang saya sampaikan topik untuk tulisan saya ini jadi terkait dengan penguatan hukum dalam menghadapi perkembangan keuangan digital. Barangkali Bapak Ibu semua kita selama 2 tahun ini di masa pandemi ini barangkali kita semua itu mengalami ya hal yang sama, tidak hanya mungkin di Indonesia tetapi juga secara global kita banyak menjadi ada percepatan ya, akselerasi penggunaan digital yang sebelumnya kita tidak membayangkan bahwa secepat ini ya. Kita 2 tahun ini kan jarang sekali atau terbatas lah ya menggunakan secara fisik gitu ya. Apakah kita misalnya keluar rumah itu kan juga dibatasi, termasuk dalam hal barangkali kita bekerja ya, berkegiatan dan juga barangkali kita termasuk di dalam kegiatan yang lainnya. Jadi memang latar belakang tulisan saya ini adalah terkait dengan kita selama pandemi ini banyaklah perubahan ya, perubahan yang dulu kita selalu menggunakan secara fisik ya, tetapi setelah di masa-masa pandemi dan juga sekarang pun akhirnya kita sedikit banyak itu ada ketergantungan di dalam menggunakan teknologi informasi dan komunikasi. Apakah dalam hal ini itu adalah negatif? Tentu saja tidak, tetapi tentu kita juga harus melihat di dalam perspektif karena kita itu adalah orang hukum ya, barangkali kita juga harus melihat dari perspektif hukum. Selain juga tentu terkait dengan perkembangan di bidang ekonomi ya, yang tentunya itu membawa dampak gitu ya. Namun juga tidak sampai terabaikan karena kita di bidang hukum ada hal-hal yang menurut saya itu juga harus menjadi perhatian. Di dalam perkembangan digital ini barangkali beberapa hal yang sudah ada, aturan-aturan terutama juga yang terkait misalnya terkait dengan penggunaan ya di bidang jasa keuangan itu juga seperti kita ketahui yang mana di dalam penggunaan digital ini di dalam keuangan, jasa keuangan itu di bawah OJK dan juga Bank Indonesia. Namun tentu saja kalau kita cermati bahwa masih banyak ya yang kita melihat ya, kalau kita mendengar atau melihat kasus-kasus yang ada barangkali di internet, kemudian di televisi ya, banyak hal-hal yang barangkali itu patut menjadi perhatian di dalam penggunaan digital khususnya yang terkait dengan di sektor jasa keuangan. Tidak kita pungkiri memang bahwa di dalam penggunaan finansial digital ini memang perkembangannya demikian pesat ya. Kita memang kalau dulu misalnya saja kalau misalnya membeli sesuatu ya harus ke suatu tempat, misalnya juga misalnya harus membayar cash, tetapi kan sekarang kita sudah banyak meninggalkan cara-cara seperti itu. oleh karena itu di dalam perkembangannya fintech atau perusahaan di bidang jasa keuangan ini juga sangat perkembangannya pesat, sehingga banyak misalnya usaha-usaha rintisan ya yang masih awal gitu ya, menggunakan platform digital yang tentu saja ini sedikit banyak juga kalau kita amati adalah ada segi positifnya ya, karena memang dapat menyerap ya, banyak menyerap tenaga kerja. Barangkali kita mengetahui banyak perusahaan-perusahaan ya yang itu banyak terjadi pemutusan hubungan kerja, tetapi dengan perkembangan di bidang digital ini sangat membantu di dalam pertumbuhan dan perekonomian di Indonesia. Banyak layanan keuangan digital, barangkali kita semua itu pernah ya menggunakan layanan keuangan digital ini, ada yang di bawah Bank Indonesia ataupun juga di bawah OJK. Misalnya saja terkait dengan e-money gitu ya, kita barangkali juga sering menggunakan, atau misalnya e-wallet ya, kita seringkali misalnya mengisi GoPay ya, mengisi OVO ya. Jadi sekarang ini tidak perlu membawa uang banyak-banyak gitu ya di dompet ataupun di tas ya. Yang penting kita bisa mengisi ya, seperti itu. Jadi kita juga seringkali ada ketergantungan juga ya, misalnya kita kalau tidak bawa HP gitu, kadang juga rasanya ada yang kurang ya, misalnya mau beli sesuatu, mau misalnya pergi ya ke suatu tempat ya, kita sangat sudah tergantung ya dengan penggunaan teknologi ini. Banyak juga yang juga ya, misalnya saja ada payment, ada QRIS ya, menggunakan barcode ya, ini juga lebih aman. Kemudian yang menggunakan layanan keuangan digital di bawah OJK itu juga sering kita dengar, yaitu penggunaan fintech lending atau peer-to-peer lending, atau juga misalnya ada bank digital ya. Jadi kita bisa misalnya tidak perlu datang ke bank, bisa misalnya untuk membuka tabungan ya, kita bisa menggunakan layanan-layanan secara digital. Termasuk juga misalnya kita menggunakan pay later ya, kalau misalnya kita menginginkan, ada Shopee, ada Traveloka ya, kita banyak dimudahkan memang dengan perkembangan layanan keuangan digital ini. Namun tentu saja semakin banyak perkembangan atau pertumbuhannya, tentu juga yang perlu dicermati adalah terkait problemnya ya. Problemnya apa? Kalau kita lihat barangkali atau kita cermati yang ada di masyarakat adalah apakah misalnya di dalam penggunaan transaksi digital keuangan ini apakah sudah aman, atau misalnya kita aman apakah dananya, ataukah misalnya keamanan data pribadi kita apa juga sudah aman ya. Ini juga yang perlu menurut saya diperkuat regulasinya, sehingga kalau misalnya terjadi ada kebocoran terkait dengan data pribadi, kemudian ada misalnya dana-dana kita yang tersimpan itu misalnya kemudian berkurang ya, ada perlindungan terhadap pengguna ya. Selama ini saya melihatnya bahwa regulator, yaitu ada OJK, ada BI ya, banyak aturannya ya, banyak regulasi yang dikeluarkan. Saya amati hampir setiap tahun ada aturan-aturan baru, ya. Namun kalau saya cermati bahwa aturan-aturan ini nampaknya tidak sampai atau belum ya memberikan penguatan terhadap kedudukan hukum pengguna jasa keuangan. Yang saya cermati adalah bahwa termasuk ada POJK yang baru, itu misalnya saya melihat bahwa konsennya itu hanya kepada pelaku usaha saja, ya. Misalnya yang terbaru ada POJK yang terbaru itu bahwa untuk misalnya mendirikan fintech, modalnya yang diperbesar, ya. Padahal sebetulnya masalahnya atau problem bukannya kan bukan di situ. Kalau yang mempunyai dana, ya, mau ditinggikan berapapun, ya, untuk mendirikan suatu perusahaan atau di bidang fintech, khususnya terkait dengan peer-to-peer lending, itu tidak masalah, ya. Namun sebetulnya kalau kita amati kasus-kasus yang ada, kan bukan itu masalahnya. Banyak orang yang kemudian merasa, ya, ada data-data pribadinya yang itu di-share gitu, ya, dengan cara-cara yang kurang baik gitu, ya. Ada yang merugikan lah, ya, kalau misalnya dia itu misalnya ban prestasi dan seterusnya. Ini yang juga saya lihat di webnya OJK juga masih ada, misalnya data-data fintech itu yang ilegal, ya, yang peer-to-peer lending ilegal itu ada. Menurut saya ini juga harus segera dilakukan tindakan. Kalau kita lihat di televisi gitu, ya, ini yang ditindak kadang hanya karyawannya saja, pekerjanya saja, ya, yang kita saksikan bersama-sama itu di TV adalah pekerjanya. Tetapi penyelenggaranya itu tidak tersentuh oleh hukum. Oleh karena itu menurut saya adalah bahwa ini yang menjadi problem hukumnya. Ini yang harus diperkuat, ya, bahwa bagaimana orang yang menggunakan itu merasa aman, ya, merasa terlindungi, ya, sehingga tidak terjadi hal-hal yang kemudian mempermalukan, ya, ada hal-hal yang tidak senonoh gitu yang di-share, ya, kepada publik. Kemudian masalah yang lain adalah bahwa dengan perkembangan yang pesat tadi, ya, di bidang transaksi digital ini, menurut saya adalah bahwa seharusnya juga diperkuat bagaimana agar sebesar-besarnya membawa kontribusi pada ekonomi di Indonesia, ya. Jangan sampai kemudian transaksinya itu luar biasa, penggunanya besar, ya, tetapi dananya lari keluar, ya. Inilah yang juga harus dicermati barangkali, sehingga kalau saya baca beberapa hari yang lalu, ya, barangkali Bapak Ibu juga mengikuti yang disampaikan oleh Menteri Menkominfo gitu, ya, yaitu terkait bahwa akan ditertibkan terkait dengan PSE, ya, atau yang banyak beroperasi di Indonesia. Ada Google, ya, ada Facebook, ya, ada Bukalapak, banyak yang mereka berkegiatan atau mencari keuntungan di Indonesia. Ada PSE yang kemudian saya lihat itu bahwa tidak hanya misalnya PSE itu lokal atau domestik, tetapi BSE asing itu juga banyak, ya. Kemudian mereka mencari keuntungan di Indonesia, ya. Oleh karena itu agar mereka itu juga memberikan kontribusi, ya, terkait dengan semakin banyaknya atau berkembangnya penggunaan di bidang digital ini, maka harusnya ada sinergisitas antara kementerian, ya, di dalam membuat regulasi, apakah terkait dengan Kementerian Perdagangan, ya, kemudian Kementerian Keuangan ataupun Kominfo, ya, sehingga mereka, ya, mencari keuntungan di Indonesia itu juga harus berkontribusi, ya, terhadap perkembangan ataupun pertumbuhan di ekonomi di Indonesia. Artinya jangan sampai kemudian kita itu sebagai pengguna, ya, tetapi mereka tidak berkontribusi terhadap secara ekonomi, ya, membawa keuntungan bagi Indonesia. Maka perlu ada harmonisasi produk undang-undang yang mana itu akan memberikan penguatan, ya, di dalam perkembangan ataupun pertumbuhan di bidang keuangan digital. Barangkali itu yang bisa saya sampaikan. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Hermastuti. And ladies and gentlemen, she argues that we have various problems financially during the pandemic, and we have dependent on the digital technology, and it has both positive and negative impacts. And what's that? Regulations have been made to protect people from the cases of cyber crimes, and it's about the legal protection of the digital service of economic transaction. And then there are two regulations. The first is a ministerial regulation of the Ministry of Communication and Information Technology, number 20 and 20. And the second is the ministerial regulation of the Ministry of Communication and Information Technology, number 10, 20 and 21. Both lead to critics. Both have taken a side of corporations and business institutions instead of protecting the people's right. And the last is national economic recovery is important, but human rights is also crucial and fundamental. Okay, ladies and gentlemen, I'd like to open questions here. Please raise your hand, and then, yeah, one, and then only one. Okay, please. Your name. The question is for a specific speaker. Yeah, and please shorten the question. Okay. Yes.
Makasih, thank you. Assalamualaikum warahmatullahi wabarakatuh. Ya, saya kira apa yang baru dipaparkan tadi soal bagaimana teknologi yang dicirikan oleh digitalisasi pada abad ke-21 ini. Sehingga orang menyatakan bahwa abad 21 inilah menjadi abad kejayaan teknologi. Sehingga begitu banyak diberikan kemudahan oleh manusia di jagat raya ini. Inilah mungkin abad yang paling banyak memberikan kemudahan kepada manusia. Nah, berangkat dari situ saya kira juga memang tidak bisa terlepas yang namanya positif dan negatif. Seperti pisau yang bermata dua. Apalagi kita melihat, ya, ada beberapa saya kira yang nampak sekali kelemahan, misalnya bagaimana kelambatan atau proteksi, ya, dari pemerintah yang seharusnya menyiapkan tentu regulasi Tetapi saya kira apa yang kita lihat, katakanlah contoh konkret seperti Undang-Undang Perlindungan Konsumen. Karena mau tidak mau, saya kira ini berbicara masalah kerugian nasabah dan lain-lain sebagainya, tentu ia adalah konsumen. Tapi kalau dilihat regulasinya, itu Undang-Undang Nomor 8 tahun 99 tentu tidak memadai untuk merespon ya perkembangan atau dinamika yang ada seperti yang disampaikan tadi Ibu. Justru apa yang kita lihat orientasinya sekarang justru apa yang dikeluarkan oleh regulator, baik itu masalah peraturan kementerian, justru banyak memberikan proteksi atau perlindungan kepada pengusaha itu sendiri, atau tentu dalam hal ini pemilik bank atau perbankan. Itu satu saya kira soal aturan atau regulasi yang agak tercecer ketimbang dengan dinamika ekonomi yang begitu cepat, yang begitu dahsyat. Yang kedua, yang nampak juga adalah tidak adanya harmonisasi atau sinkronisasi aturan. Kita melihat Menteri Perdagangan yang tentu leading sektornya kalau kita berbicara soal perekonomian, perindustrian, kemudian di instrumennya yaitu soal digital ada di Menko Infocom. Lalu kemudian di perbankannya itu sendiri, ya, meskipun sudah ada misalnya OJK yang melekat di situ, tetapi juga kalau kita lihat juga tidak mampu untuk memberikan perlindungan kepada nasabah, dalam hal ini konsumen. Kita melihat berbagai kasus yang muncul, ya, itu tidak kelihatan. Ya. Kemudian saya kira dia mungkin ke depan dengan persoalan ini, kalau kita berbicara ekonomi, tentu kalau kita lihat di konstitusi kita ada di pasal 33. Mau tidak mau kalau berbicara masalah ekonomi di Indonesia, tentu itu dibunyikan di pasal 33. Oleh karena itu saya kira ke depan, ya, mungkin ya jika ada amandemen ini perlu menjadi perhatian juga. Bagaimana supaya secara eksplisit juga dimasukkan dalam konstitusi kita. Saya kira untuk sementara demikian. Assalamualaikum warahmatullahi wabarakatuh.
Baik, Bu Hera. Yes, please, to answer the question, you can answer the question in Bahasa Indonesia as well.
Terima kasih Bapak bahwa apa yang disampaikan oleh Bapak dari mana Pak?
Universitas Islam Jakarta, UIJ. Oh,
tuh, ya. Biar kenal ya Pak ya, biar tahu ya. Dari Universitas Islam Jakarta. Benar apa yang disampaikan oleh Bapak tadi, bahwa itulah yang kita rasakan, bahwa jika ada kasus-kasus, kenapa ya institusi terkait itu kok malah tidak mengambil peran. Yang kita lihat kan seperti itu. Banyak kasus yang itu nyata ya di publik, dan mereka tidak berbuat apapun ya di dalam merespon fakta-fakta dan kasus-kasus yang terjadi. Apa yang disampaikan tadi oleh Bapak bahwa memang kalau saya melihat bahwa perkembangan ekonomi saat ini memang demikian pesat ya. Tadi sudah saya sampaikan, diikuti dengan perkembangan digital yang tentu saat ini dan ke depan itu tidak akan flashback ke belakang, tetapi pasti akan semakin cepat ya pertumbuhannya. Oleh karena itu betul bahwa regulasi yang ada, apa yang saya sampaikan tadi, memang antara misalnya departemen satu dengan yang lain itu tidak ada harmonisasi di dalam misalnya produk perundang-undangan, sehingga kadang itu tidak ada sinergisitas antara departemen. Apakah misalnya terkait dengan regulasi yang ada ataupun kebijakan-kebijakan yang ada. Seringkali kalau kita lihat ini misalnya, kalau misalnya sekarang itu terkait dengan di bidang teknologi, di bidang digital, tentu harus juga barangkali karena di bidang keuangan OJK dan BI tentu harus juga ada sinergisitas dengan Kementerian Info. Kenapa? Lah kalau misalnya itu ada pelanggaran-pelanggaran, kenapa tidak langsung saja misalnya diblokir? Kalau ada kasus-kasus misalnya yang radikal, yang porno itu kok cepat sekali ya. Tetapi kalau dalam hal misalnya pelanggaran-pelanggaran di bidang keuangan itu kok responnya lama gitu ya. Oleh karena itu barangkali itulah yang harusnya juga perusahaan-perusahaan fintech itu yang memang jelas di dalam daftarnya, di lamannya OJK itu ada. Lah ini kan harus segera dilakukan tindakan. Masyarakat itu tidak akan tahu, oh yang mana ini yang misalnya yang ilegal, mana ini yang legal, mereka kan tidak tahu. Tidak semua orang itu misalnya tahu membuka misalnya webnya OJK, kan tidak semua orang ya mengetahui. Walaupun memang ada daftarnya di OJK itu ada loh, ini loh yang ilegal, yang ini yang legal. Tetapi harusnya kan tidak seperti itu. Masyarakat harusnya tentu yang ada ini berarti ini yang legal. Ya, jadi oleh karena itu menurut saya adalah pihak regulator harusnya mengambil peran yang secara maksimal. Apalagi kasus-kasus itu sudah banyak, ya, sudah banyak dan itu tidak sama sekali ada respon yang yang memberikan bahwa harusnya mereka itu diberikan perlindungan bagaimana dan juga pihak fintechnya itu diberikan tindakan. Kalau saya lihat yang diberikan tindakan itu hanya misalnya karyawan-karyawannya itu saja, ya, tidak ada hal yang misalnya itu memberi efek jerah bagi misalnya penyelenggara fintech itu. Kemudian apa yang disampaikan tadi bahwa undang-undang itu juga karena sekarang itu sudah mengarah kepada digitalisasi di bidang keuangan, betul bahwa undang-undang perlindungan konsumen itu sudah tertinggal walaupun ada sudah undang-undang ITE, tetapi secara di dalam undang-undang ITE itu kan tidak secara substansi melindungi kepada konsumen, hanya beberapa pasal saja. Oleh karena itu memang tadi sudah saya sampaikan harus ada penguatan ya di bidang transformasi digital khususnya di bidang keuangan. Kemudian apa yang disampaikan oleh Bapak tadi juga bahwa nampaknya memang OJK, kemudian BI ini memang memberikan keleluasaan atau tadi kalau Bapak mengatakan bahwa malah memberikan proteksi ya kepada pelaku usaha. Betul ya, saya melihat ini tidak seimbang kadang regulator ini ya, tidak memberikan perlindungan kepada konsumen, justru ya kalau saya melihat regulator ini yang penting ya misalnya saja mendatangkan misalnya investor, seolah-olah seperti itu ya. Yang penting mendatangkan investor. Apakah ada hal yang dilanggar? apakah itu merugikan, itu tidak menjadi concern dari para pengambil kebijakan khususnya di bidang keuangan. Mungkin itu Bapak, terima kasih atas pertanyaannya dan masukannya ya Bapak.
Okay, is there any questions? Please silahkan bagi ada yang punya pertanyaan. Oke, tidak ada. Dr. Fernando, to invite you to, deliver such a 2 to 3 minutes of intellectual reflection based on your presentation. Please, Doctor.
Yeah, thank you very much. First of all, I apologize because I cannot understand your beautiful language, so I was not able to follow the whole presentation of my colleague. Well, just in 2 minutes to close the presentation, I'd say that these issues about the issue of restriction of human rights in time of epidemics will continue to be an issue of a current issue, an issue of a current debate, because we are still under the pressure of an emergency situation, and apparently the COVID emergency will continue in the following years, even if not with the same strength as the beginning. And second, because we are surely going to have to face another other emergencies, other situations related to similar to those of COVID. I'm thinking about environmental crises and migration crisis, and even wars. If you think now about the war in Europe and Ukraine, so the issue of restriction of civil rights, of human rights in time of emergencies is going to be, I think, one of current interest in the following years.
Thank you very much, Dr. Fernando. Ladies and gentlemen, thank you for joining us. And this is the last, plenary session. This is the second part of the plenary session that we have. And I'd like to say once again, thank you for all. And I'd like to pass this forum to our dear sister, Master of Ceremony, please. Thank you, Bapak Ibu sekalian. Assalamualaikum wabarakatuh.
Thank you so much again, Pak Hasnan, and also Dr. Herawastuti and Dr. Fernando's there, through Zoom. And I have several notifications, by the way. Oh, thank you so much. I personally, even though I'm not coming from law department, I learned a lot of things today. So thank you so much. And Bapak Ibu, again, if you're watching me now on Zoom, I'd like to remind you back again to fill in the certificate link, the attendance link, because you will get your certificate right after you fill in the certificate. Make sure you check on the chat box, and if you didn't see any link yet there, make sure you also chat the committee. They will send it back to you on the chat box. And there is also another announcement that tomorrow, Bapak Ibu, the breakfast will be ready at 6. Jadi jam 6 subuhan, jangan tidur lagi. Let's have a breakfast for tomorrow. And worry not, tomorrow also there will be committee that will pick you up to our UMM, Gedung Universitas Muhammadiyah Malang, because we are not going to have the discussion here anymore. So the discussion will be in GKB4, Gedung Kuliah Bersama 4. There will be committee, nanti akan dijemput Bapak Ibu, jadi tidak akan kesasar. Insya Allah. Ya, jadi gitu. Silahkan siap-siap, karena if I'm not mistaken will be started at 8 ya Pak. 8 or around 8:30 based on your rundown. So make sure karena jumlahnya banyak, jadi diharapkan untuk on time supaya nanti acara besok juga dilaksanakan dengan lancar ya. So I think that's it. And for the announcements, and again, Bapak Ibu, another announcements. If you want to stay here after this the plenary session, we will be happy because we are going to have another sessions, which is with publication team, right? With Budina again, I think. So please stay here if you have having questions and discussions after this plenary sessions. By the way, Bapak Ibu, I know you feel tired today. Maybe some of you just finished a long journey to finally arrive here in Malang. So on behalf of INCLAR committee, we would like to say thank you so much for your active participation today. But before we end this event tonight, let us together recite Hamdalah, Alhamdulillah, Hirabbil Alamin. Again, thank you so much. See you in the second round of the workshop tomorrow. I am Arum Puspitasari, signing off, Bapak Ibu. Assalamualaikum warahmatullahi wabarakatuh. Baik, silahkan selanjutnya adalah